Tragic events that occurred at Westfield Bondi Junction on Saturday the 13th of April 2024. That is the killing of 6 people, the death of Joel Couchy, and injuries to many others, both physical and psychological. I wish to make some very short remarks before turning to Dr. Dwyer to deliver her opening. I've previously offered my condolences to the families, and I do so again today. There are simply no words that can properly convey the magnitude of your loss. I acknowledge the grace and courage, strength and dedication of each of the families of Ms Singleton, Jade, Ms Cheng, Ms Good, Faraz and Ms Darchia in engaging with this coronial process and in tirelessly advocating for their loved ones. I also recognise the emotional fortitude and resilience it takes to participate in this process only a year after the tragic events of the 13th of April 2024 and indeed soon after the 1-year anniversary. Throughout the next 5 weeks, the team assisting me will continue to engage with the families and their legal representatives and of course other interested parties and stakeholders to conduct this coronial process in an efficient and trauma-informed manner. Our ultimate hope is to provide families and their loved ones, and also the broader community, with much-needed answers about how the tragic events of the 13th of April 2024 occurred and how such events might be prevented in the future. I thank all parties involved in these proceedings and their legal representatives for their assistance to date. This inquest has moved to hearing as quickly as has been humanly possible, allowing, as we had to, for the thorough investigation to be completed. The investigation has been searching and comprehensive. I understand some further material will be received during the course of the hearing from interested parties. No doubt parties will continue to work constructively with counsel assisting to manage the further material to be provided as they have done to date. There is one final matter I wish to raise. At the last directions hearing, reference was made by counsel for the families and by senior counsel assisting to the potential for harmful media reporting of these proceedings. Accepting that there is an important role for open justice in our society, I can only underscore in the strongest terms the need for empathy and sensitivity in the coverage of this inquest, given the immense trauma that each family has suffered to date. I'll now hand over to Senior Counsel Assisting Dr. Dwyer.
Your Honour, I estimate that my opening will take around 2 hours, so we'll have a break for morning tea. As Your Honour and families know all too well, this inquest will explore the tragic events of Saturday the 13th of April 2024 that unfolded at Westfield Bondi Junction. The events of that day, the anniversary of which have just passed, have forever changed the lives of the victims, the families and loved ones, those who were injured, those who were present, and the community at large. Some of the events are already well known. On the 13th of April 2024, Joel Couchy, then aged 40, killed 6 innocent victims. 5 were women: Dawn Singleton, Jade Young, Ishan Cheng, Ashley Good and Pikria Darchia. Mr Couchy also killed a security guard, a young man named Faraz Tahir. It was his first ever shift at Westfield Bondi Junction as a security officer. Mr Couchy wounded 10 others before being fatally shot by New South Wales Police. Of those 10 people, 2 were men, and both of those men were very seriously injured. While the inquest will explore what happened on that day on the 13th of April 2024, it is not confined to those events on that day. A detailed issues list has been distributed to parties and has been shaped with the assistance of those who lost their loved ones. I'll go further into those details shortly, but in summary, the inquest will review Mr Couchy's mental health treatment in Queensland, including the decisions that led up to a reduction and ultimately cessation of medication that had previously been prescribed to manage Mr Couchy's mental health. It will review the apparent gaps in the Queensland mental health system that Mr Couchy fell through, which meant that he was effectively without treatment and without adequate supervision for nearly 5 years before his death, even though he had previously been medicated and well supervised. Although, as I will set out, Mr Couchy did have a few brief interactions with the medical profession, from early 2020 there was nothing in the way of active supervision, monitoring or follow-up. This inquest will explore Mr Couchy's interactions with Queensland and New South Wales Police and consider if any opportunities for intervention were missed, and if so, how the system can be improved to assist frontline police who are increasingly being asked to deal with members of the public who appear mentally disturbed and are not receiving adequate psychiatric care. Your Honour, I expect the court to hear from experts about a paucity of community-based care for mentally ill men like Mr Couchy and why that is a burden increasingly being felt by police and the broader community. And I expect that there will be some serious practical recommendations that arise in that regard. It's not proposed or intended that this inquest will be a roving inquiry delving into the totality of issues facing the mental health system in this state of New South Wales or Queensland. It may be accepted that the mental health system in both New South Wales and Queensland is under strain, and it's neither possible or appropriate for this inquest to seek to identify how to reform the entirety of the mental health system. But through the lens of Mr Couchy's lived experience and in recognition of the devastating consequences caused by his actions, the inquest will seek to identify practical and realistic recommendations about what can be done to improve the treatment of those suffering from chronic and severe mental health conditions, with a particular focus on schizophrenia. It is hoped, Your Honour, that this inquest and Your Honour's findings will offer a meaningful and informed contribution to an area that is in need of urgent reform and resourcing. A further topic for this inquest to investigate is how the operator of Westfield Bondi Junction, known as Centre Group, and its security contractors and New South Wales Police and New South Wales Ambulance responded to the events of the 13th of April 2024, including whether they were adequately prepared to deal with the violence that unfolded on that day on such a significant scale, and whether they were adequately prepared to deal with the number of casualties and what, if anything, could have been done differently. The court is not interested to single out any single individual who was doing their best in a fallible system that was put to the test by Mr Couchy's acts of violence. It is necessary to establish an authoritative account of the events of the 13th of April and relevant prior matters. And of course, individuals will be called to assist with that, and they have already been called on to give a detailed written account. But individuals are encouraged to give a frank and full account of their experience, knowing that the goal of this inquest is to work out what happened and why, in order to identify any gaps in systems and processes and to learn valuable lessons from any mistakes that were made, allowing this court to make recommendations that might save lives in the future. We're very fortunate in Australia that this type of terrible tragedy that unfolded on the 13th of April 2024 happens rarely, but that is little comfort to those who have lost a loved one. Resources have been invested in this inquest to understand what happened, to recommend what is possible to prevent it happening again, and to ensure that if it ever does happen, the response to it by emergency services will be as rapid and as effective as possible. This morning, I will provide an overview of the matters that will be canvassed during this inquest over the 5 weeks. I'll provide a summary outline of the evidence, which comprises witness statements, documentary records and electronic materials as it currently stands. That evidence will further emerge over the next 5 weeks, as Your Honour hears oral evidence from witnesses, many who were directly involved in the events of the 13th of April. Your Honour alluded to the fact that further evidence comes in during an inquest, and we are mindful of the way that parties have been moving as quickly as possible to put that evidence on. There's one final matter I'll address at the outset before we get into the facts, and it's really just to echo what Your Honour has already said this morning by way of opening. We understand that there's a genuine public interest in the matters to be addressed in this inquest. We know that the media are present today and will be reporting on the evidence. That's a function of open justice and an active democracy. It's the reason for the live stream of selected parts of this inquest, which may include expert evidence and ultimately the findings. The public are interested, but also experts in the particular areas that the inquest touches on are interested to understand the issues and to learn from them for their own purposes, for the sake of the community. So the media does indeed have an important role, but we ask again that the media be conscious of the impact their reporting has already had on the families of the victims and may have again, and on all of those affected by the events of the 13th of April 2024, many of whom we will not see in this court, but who are at home and reading the media, conscious of their own experiences on that day. The grief of the families who are impacted is raw and deep, as it would be for any family, and the extent of their loss is truly unfathomable for the rest of us. We can only imagine it. The inquest is a huge strain on their emotional reserves. Most people in the community will grieve the loss of a loved one at some point in time, but they generally get to do so in their own private way, in their own private time. We all think of what happened in this case every day, and we empathise deeply with families who've lost a loved one. We also remember where we were that afternoon when the events unfolded. That afternoon, families, as so many other people around New South Wales, heard breaking news about a public emergency at Bondi Junction, and they immediately made calls to check on the people they loved, as so many thousands of people must have done on that day. But for the families involved in this inquest, they were to discover that a public tragedy had touched on them personally and profoundly and irrevocably. So the public nature of this grief is a burden for the families that we are trying to be mindful of at every stage of the inquest. Your Honour has urged the media to be sensitive to the families' requests. The families' lawyers are here to guide the media if necessary, if they have any questions in that regard about how to be respectful. And non-publication orders have been put on by Your Honour to assist the media with the boundaries of what is in the public interest, and that has been done in consultation with the families. Your Honour and those assisting has emphasised that these proceedings will be trauma-informed to the extent that we possibly can be. And as a corollary of that, and as I said at the last directions hearing, sensitive footage will not be played in open court. We concern not to unnecessarily traverse any graphic detail in the oral evidence or in this opening. However, to be clear, much of the traumatic footage of what happened on the 13th of April, which includes Mr. Couchy running through the centre with a knife approaching victims, is in the public domain, but is not in the brief of evidence. We do not think that playing that footage in open court serves any forensic purpose. We hope that individuals from the media outlets who are reporting upon the inquest can exercise their own judgment about what is played and what is being replayed to the public, mindful of the preferences of families and the pain and suffering they have expressed. Access to witness statements will be made available to the media following the conclusion of the relevant witnesses' evidence. The index to the brief will also be made available. To the extent access to further material in the brief is sought, and acknowledging the sensitive nature of much of that material, it will be conditional on the media making an application to Your Honour, and that application should clearly identify the specific material to which access is sought and the reasons for the access. Acknowledging the volume of material in the brief, those applications will be considered by Your Honour as quickly as possible, and we are mindful of open justice, but a priority of this court and therefore this council assisting team is to be careful and to support the families through this process. So it will be necessary to carefully check documents prior to their release and to assist the media to understand the non-publications order in place. So there may be a need for patience. I come now to the purpose of an inquest. To assist the community to understand what an inquest is all about and why it happens, and why the government have carefully resourced this inquest, I'll explain again that this inquest is mandatory according to the New South Wales Coroners Act. Sections 23 and 27 of the Coroners Act provide that an inquest must be held where it appears that an individual has died as a result of a homicide, or where a person has died as a result of a police operation. I mean by that, of course, that Inspector Scott was required to fatally shoot Mr Couchy, and that is a police operation. So for both of those reasons, an inquest in this case must be heard. A coronial inquest is fundamentally different to an ordinary court hearing. No one in the court is accused of a crime. There are not civil proceedings concerned with compensation. And as I've previously stressed, guilt or innocence or liability is not what a coroner's court is all about. This is a fact-finding jurisdiction. Your Honour is tasked with investigating the identity of those who have passed away, which of course is well known in this case, as well as the date, the place, and what's referred to in the Act as the manner and cause of persons' deaths. Manner of death really means the circumstances leading up to someone passing away and the surrounding issues. In undertaking the investigation, the court has a broad remit and a broad discretion to consider a wide range of matters within its jurisdiction. And importantly, as I've already touched on, Your Honour has a power to make recommendations in connection to a death, including matters concerning public health and safety. And that, of course, is also the reason why the government has seen fit to resource this inquest so significantly, because it is of such great importance to the community that any public safety lessons are learned. Before turning to an overview of the matters to be addressed during the inquest, I'll just give a brief outline about how the inquest will run over the next 5 weeks. Consistent with Your Honour's direction about the inquest being trauma-informed, the council assisting team has emphasised again and again the need for us to finish during that period. We do so having consulted the families. As to the procedures to be followed, council assisting will be principally responsible for examining the witnesses who are to be called. Your Honour will hear oral evidence from over 40 witnesses during the hearing, so that it is essential that the proper and efficient conduct of the inquest be at the forefront of parties. That means we need to avoid duplication, and all the experienced counsel at this bar table understand that. So most of the questions are asked by counsel assisting, and we ask people to avoid duplication. We doubt that stopwatch orders will be necessary, but they're available to Your Honour. So.
Can I just pause for a moment to ask anyone who is listening in remotely to put your microphone on mute? Thank you.
A small number of witnesses have made applications to be excused from giving oral evidence, and they are witnesses who would have ordinarily be called, but they've asked to be excused due to their health and well-being, either physical or mental health. They were individuals who give evidence directly relevant to the events of the 13th of April 2024. We understand interested parties, and particularly families, need to carefully understand the events of that day. In a small number of cases, Your Honour has determined to excuse witnesses based on compelling medical evidence that they have provided. That only relates to a very small number of witnesses. The medical evidence they provided demonstrates that the risk posed by requiring those witnesses to relive the events of the 13th of April far outweighs any potential benefit that might be obtained from hearing evidence from that person. But importantly, those witnesses who've asked to be excused have each given detailed written accounts of their movements, and they have offered to provide supplementary statements answering further questions that have been put to them by the counsel assisting team in consultation with the families. They have cooperated with that process. The counsel assisting team is confident that by the end of this inquest, all the necessary information will be before this court to enable Your Honour to make the necessary findings and, crucially, the recommendations. The scope of the inquest is informed by the issues list. That document has been prepared again on a collaborative basis with the interested parties and particularly with the families. We again acknowledge the contribution of families who we're asking to participate at a time very soon after they are coming to terms with the loss of their loved ones. The issues list, which is available, identifies 17 discrete issues and multiple sub-issues that will be explored during the inquest. I touched on that issues list and read from it during the last directions hearing, so I don't propose to do so again in detail. However, I can say from the outset, by way of an overview, that the following matters will be central to the inquest and the evidence to be heard. Firstly, of course, the events of the 13th of April 2024, including the level of preparedness for an active armed offender. That's a particular term which is used by security and has a particular meaning. It will be referred to by its acronym in some documents as AAO, Active Armed Offender, and it has international currency. Your Honour will look at the response by each of the centre group and its security contractors, New South Wales Police and New South Wales Ambulance on that day. And in particular, the inquest will explore the initial response by security staff at Westfield, including when staff first became aware of what Mr Cauchi was doing and what actions were taken in response to what he was doing, and the nature and timing of any alerts that were set up as a result. And I'll come to that in more detail shortly in my opening. Secondly, the court will look at the New South Wales Police response, including the actions of Inspector Amy Scott in apprehending or attempting to apprehend Mr Cauchi and fatally shooting him. It will also look at how New South Wales Police interacted with New South Wales Ambulance and with Westfield or Centre Group staff, and the implementation of the relevant command structures, as well as the potential identification of an additional offender. So Your Honour will recall that on the day there was some level of confusion as to whether or not Mr Cauchi was acting alone, and that had implications for the response of first offenders, and we'll look at that and the first responders, and we'll look at that and the response. The timing and nature of the response by New South Wales Ambulance to this mass casualty incident is an important topic. It includes first aid treatment and triage decisions of New South Wales Ambulance paramedics. It will also consider what, if any, consequences resulted from the declaration of Westfield Bondi Junction as a hot zone following the possible identification of a second offender. None of that is intended as a criticism of individuals doing their best in that chaotic environment, but it is important to learn from this catastrophic event. As I've already touched on, Mr Cauchi's mental health treatment in Queensland is a very important topic. That includes his treatment for schizophrenia and the decision to reduce and ultimately cease his psychotropic medication, the consequences of that reduction, whether there were early warning signs of a relapse. That includes early warning signs in late 2019 and early 2020, very shortly after he was taken off that medication. And if there were any opportunities for an intervention that may have prevented what ultimately occurred on the 13th of April 2024. We know from the evidence in the brief that Mr Cauchi had several interactions with Queensland police officers, including most notably in January 2023, where Queensland police were called to Mr Cauchi's family home following an incident where his father had confiscated a number of knives that were a similar style to that used by Mr Couchy on the 13th of April 2024. Mr Couchy's father was worried about him having those knives, and the court will explore whether that was an opportunity missed for intervention by police, which may have resulted in Mr Couchy being re-engaged with the mental health system at that time. The inquest will also consider, at the specific request of families of victims, the nature of the media's response in the aftermath of the events of Westfield Bondi Junction on that day, the 13th of April and beyond. And it's expected that family members will give witness statements detailing their experiences with media in de-identified form following the events and the impact of them, to see whether or not anything can be learnt and done differently next time. Given the inquisitorial nature of these proceedings, other issues may emerge during the hearing, and we stress that the issues list is not a form of pleading like in a civil case that binds Your Honour. It's not an indictment like in a criminal case where there is difficulty changing it. Rather, it's a guidepost to keep the inquest on track and put parties on notice of the main issues that we expect to be heard. By way of a hearing plan, and this is the last thing I'll say before I outline the facts, it's anticipated that the 5-week hearing will proceed as follows. In weeks 1 and 2, that is this week and next, Your Honour will hear evidence from those directly involved on the 13th of April. The first witness will be Detective Chief Inspector Andrew Marks of the New South Wales Police Homicide Unit, who, along with his diligent team, has been responsible for the investigation into the events that occurred at Westfield Bondi Junction. And Your Honour will hear that Detective Chief Inspector Marks was involved from day one, the 13th of April, and has continued his involvement. Your Honour will also hear this week from Inspector Amy Scott, the New South Wales Police first responder, who confronted Mr Joel Couchy and who shot him as he was armed and running towards her at speed. Inspector Amy Scott is an important witness, no doubt. Evidence will be called from her tomorrow. But, Your Honour, there is no question with respect to the propriety of her actions. And in fact, her professionalism and courage on the 13th of April 2024 is clearly beyond doubt. Having spoken with Inspector Scott, I expect that she will also want to give evidence about the courage of others on that day. Your Honour will also hear from other first responders from New South Wales Police and New South Wales Ambulance who will speak to their experiences on the 13th of April, as well as from Centre Group security staff, including security subcontractors who were confronted with something that was beyond their imagination. Consistent with Your Honour's instructions to conduct this inquest, being trauma-informed, the counsel assisting team, in conjunction with discussions with families, has determined not to call civilian witnesses to give evidence of what they observed on the 13th of April, with a limited exception that I'll come to. The court has the benefit of nearly 250 statements from civilians present at Westfield Bondi Junction, and that comprehensively covers their respective accounts. It's therefore, in our respectful submission, not necessary for any of those witnesses to be called to give oral evidence to relive the events of that day, and indeed it's the specific wish of families that they not have to do so. There are two exceptions to that position, and that is we will be calling Mr Silas Desperoux and Mr Damien Garot, who are likely already known to many. Silas and Damien confronted Mr Couchy during the attacks, and they helped direct Inspector Amy Scott to locate Mr Couchy. They were witnesses to the eventual shooting of Mr Couchy, and we understand that both of those witnesses are comfortable to give evidence in this inquest, and they'll do so tomorrow. Finally, with respect to the first 2 weeks, we will also hear from those members of Queensland Police who interacted with Mr Couchy in the period where he was unmedicated and operating outside of the mental health system in 2022 and 23. And that's done with a view of the importance of understanding what more, if anything, could have been done in relation to those interactions. Your Honour also, for the most part, has the benefit of body-worn video that was turned on by those police officers, so you're able to see how Mr Couchy was presenting at that time. We'll hear from police officers about his presentation as opposed to very many members of the public with a mental illness who they are required to deal with on a day-to-day basis, and how to distinguish between those who are in need of more urgent attention and what resources are available to them in those circumstances. In week 3, the court will focus on individuals who were involved in Mr Couchy's mental health treatment in Queensland. That includes psychiatrists, particularly the psychiatrist who saw Mr Couchy for over a decade. It includes psychiatric nurses, and it includes general practitioners. It's anticipated that this evidence will address the circumstances that led to Mr Couchy disconnecting from the mental health system by early 2020. Among other matters, as I've already said on numerous occasions, the court seeks to understand whether there were opportunities to reintegrate Mr Couchy that were missed or could have been pursued more assertively. Week 4 will primarily comprise evidence from various experts that have been retained by Your Honour and the parties, or retained on behalf of Your Honour and the parties. Your Honour will have the benefit of hearing from preeminent experts on topics that are of critical importance to the inquest, including from international experts where they are relevant. We acknowledge the dedication of those experts to assist this inquest and prepare the reports so promptly, and to take time out of their other work, putting it to one side so that this can be their priority. I will briefly canvass now those various experts in the disciplines that we will cover. As a security expert, Your Honour will hear from Mr Scott Wilson. He's an international expert in counter-terrorism, policing, security and crisis management, with over 31 years of policing experience in the United Kingdom. Mr Wilson has previously assisted the commissions of inquiry into the Manchester Stadium bombings and the Christchurch mosque attack. Mr Wilson will give his expert opinion as to the preparation and response of each of Centre, its security contractors, New South Wales Police and New South Wales Ambulance. It's not suggested that this is a terrorist attack, what happened on the 13th of April, but there are similar type of responses required when you have a mass casualty event, and Mr Wilson, we believe, is expertly placed to have assessed the response of those groups just mentioned. He will come to Australia for the purposes of giving oral evidence. Secondly, Your Honour will hear from general practitioner experts, Dr Hester Wilson from New South Wales, who has given evidence in this court on numerous occasions, and Dr Edwin Cruz from Queensland. They'll give their expert opinion in respect to the treatment Mr Couchy received from general practitioners in Queensland during the period in which he was medicated for his schizophrenia and in the period after medication ceased. The third category relates to the medical response to the events of the 13th of April 2024. Your Honour will hear evidence from Dr Stefan Mazur, an expert emergency physician. Dr Mazur will give evidence about the treatment received by those who were fatally wounded by Mr Couchy. He will also opine on the adequacy of the response by New South Wales Ambulance, acknowledging, of course, as in we do and he does, the difficult circumstances that first responders were faced with. The court will hear from Dr Philip Coburn in response to a new approach to triage known as the 10-second triage tool, which has been adopted in the United Kingdom and in some parts of Europe in response to what they have had to deal with by way of mass casualties. It's anticipated that this evidence may offer very important lessons in New South Wales and throughout Australia that can be used in the future management and treatment of victims following mass casualty events. The last category relates to the psychiatric expert evidence. This inquest will have the benefit of hearing from 4 expert witnesses whose reports have been obtained by this court. That is, Professor Olav Nielsen, Professor Edward Heffernan, Professor Anthony Harris, and Professor Merit Nordentoft. Professor Nordentoft is the one psychiatric expert who is the international expert. She comes from Denmark. Further, an expert report has been obtained on behalf of one of the parties, and that is the report of Dr. Matthew Large. Each of those 5 psychiatrists are truly national and international experts. They will give evidence in a conclave. Each of the experts will draw on lessons from their own jurisdictions, and they'll provide their views on Mr. Couchy's mental health treatment over the course of his life and his mental health as at the 13th of April 2024. Further, they will seek to identify any missed opportunities that could have resulted in Mr. Couchy's reintroduction to the mental health system. They will express their views on major gaps in our mental health systems in New South Wales and Queensland that allow for people like Mr. Couchy who are experiencing psychosis to fall through the gaps, and they will point to important opportunities for reform and help to shape Your Honour's recommendations in that regard. The final week of the inquest, week 5, will conclude with executive statements. The court will hear from the CEOs of Centre Group's security contractors, Glad and Falcon, from Centre Group itself, from the executives of New South Wales Police, the executive of the Queensland Police Force and the New South Wales Ambulance, all of whom have reflected on the evidence and can provide an outline of what has already been done by their agencies to respond to any perceived gaps and what they think is still to come. The hearing of this inquest will conclude with statements from families. There's no obligation or expectation in any inquest that families will participate in that process. However, the counsel assisting team and this court would welcome family members who wish to speak about their loved ones, who wish to talk about what they've lost and the impact that this has had on them and what they hope can be achieved from the inquest. At all times through the inquest, we think of them. The counsel assisting team is available at any time to speak with families about that and about any concerns they have. Family statements can be read by anyone who the family prefer to do that, including legal representatives or friends or family members themselves, and it can be delivered in whatever format a family is comfortable with. It may be that certain family statements are given in closed court if that's the preference of the families, but we'll come to that process throughout the course of the inquest. The current intention is that we sit through Monday to Friday of each week, although there are 2 Fridays that are kept in reserve as overflow days to make sure that we can finish in the 5-week timetable. So I come now to a brief overview of the evidence that it's anticipated we will hear in the 5-week period. It will necessarily be high level. The brief of evidence is extensive and it currently spans 50 volumes with approximately 1,700 individual tabs. All of that material, once the brief of evidence is tendered, will be before Your Honour as evidence to inform the issues. In that context, a central purpose of this opening is to contextualise the enormous brief that will be provided and the evidence that will be heard orally. I'm going to provide an overview of the following matters then in this order. First, the movements of Mr. Couchy on the 13th of April 2024. Secondly, the response of Centre Group, New South Wales Police and New South Wales Ambulance. Thirdly, Mr. Couchy's mental health, his mental health treatment, why that ceased, and the events that led to him falling outside the mental health system. So I come now to the tragic events of the 13th of April 2024. During the directions hearing last year, I provided a brief synopsis of those events. Investigations have continued since that time, and the counsel assisting team, with the benefit of the material and statements contained within the brief, including the extensive CCTV records, have a clear and detailed understanding of the actions of Mr. Couchy on that day, as well as the responses of the various agencies involved. It is necessary for me to once more go through those events, but at a high level and trying to be as sensitive as I possibly can and without granular detail. But even at a high level, we understand it's extremely difficult for the families. And can I take the opportunity to note again that families should feel free to move in and out of the courtroom as they please. We'll also seek to provide warnings in advance of any evidence that may be considered distressing, and no doubt legal representatives at the bar table will do the same. I'll show a number of slides during this opening. None of them are of sensitive material. It's impossible, however, Your Honour, to sanitise completely what occurred. One of the reasons for providing a broad outline at all of what occurred on the 13th of April is because we are not calling any civilian witnesses and we're not calling most of the first responders, so this is the only time that I anticipate the overview will be given. In the case of each of the victims who passed away, Your Honour determined that only an external examination was required by the pathologist who performed the examination. The medical cause of death is set out in those reports in one line as either a stab wound or wounds to various parts of the body, and I don't need to say any more than that. While the events of the 13th of April are marked with tragedy, there are also instances of hope and courage and selflessness by untrained civilian bystanders who, in circumstances of uncertainty and with no guarantee as to their own safety, provided first aid and comfort to victims. I won't identify any of those particular individuals, but I am conscious that today some of them are listening on the live stream. It's expected that Detective Chief Inspector Marks might canvass broadly how those individuals are recognised, either when he gives evidence today or at the end of this inquest. The expert psychiatric evidence is clear and unanimous that Mr. Joel Couchy was floridly psychotic on the 13th of April 2024. The accounts of several civilian witnesses who interacted with him in the days prior and those who interacted with him on the 13th of April accord with that assessment, and it's consistent with the progress of his mental illness, which was first diagnosed when he was a teenager and which was untreated and largely unmonitored in the nearly 5 years leading up to this tragedy. Expert toxicology evidence suggests that Mr. Couchy had been using cannabis or marijuana in the days preceding his death. The use of marijuana also preceded Mr. Couchy's initial diagnosis of schizophrenia in 2001, which I'll come to later in this opening. I expect the court will hear expert psychiatric evidence that use of cannabis would likely have exacerbated the psychotic symptoms that Mr. Couchy was experiencing around the 13th of April. But conversely, expert evidence is also likely to shed light on the fact that use of cannabis may be a symptom of schizophrenia or psychosis. As to whether there was any planning or motive to the attacks on the 13th of April, police investigators have reviewed numerous records from the phones belonging to Mr. Couchy, including his web browsing and messages. Your Honour, those records are distressing. They demonstrate that Mr. Couchy was a person who was extremely unwell. Searches on his phone indicate that from at least around 2022, Mr. Couchy was preoccupied with weapons, with violence, and with mass killing. There is certain evidence suggesting that Mr. Couchy's actions on the 13th of April 2024 may have been the subject of rudimentary planning for these reasons. First, he had, in the years prior to 2024, purchased several KA-BAR USMC knives, known as K-bar knives, one of which was ultimately used at Westville Bondi Junction on that day. On the 24th of February 2024, Mr. Couchy purchased the K-bar USMC knife that he was to use on the 13th of April 2024 from a Tent World store in Punchbowl. Second, leading up to the attacks, Mr. Couchy made a note on his phone, which is dated the 25th of January 2024, that read, "Call knife sharpener and confirm it doesn't need sharpening for mall use." And on the 12th of February 2024, he made a note to check out malls and also where to run. Other notes made by Mr Couchy that are dated the 31st of January 2024, the 3rd of February 2024 and the 14th of February 2024 all suggest that he was planning a strike or an attack. I interrupt myself to note that that is very different to how Mr Couchy presented or behaved or appeared to think when he was medicated. Third, the browsing history on Mr Couchy's mobile phone, beginning in around late 2022, suggested a preoccupation with death and murder. There are bookmarked pages on serial killers, searches containing mass stabbing incidents in Australia, and searches in relation to serial killers. That's all in the days leading up to the attack. Mr Couchy also searched for information concerning the Columbine shooters on the 13th of April. However, apart from this insight into Mr Couchy's inner turmoil, there is no direct evidence, there is no direct evidence indicating any motive associated with his plans. I'll repeat that. So apart from that insight into Mr Couchy's inner turmoil and his dark thoughts leading up to this incident, there's no direct evidence indicating any motive in relation to what happened. What those records unequivocally show is a man who was seriously unwell, who was far from home and far from the watchful eye of his parents, who had previously been able to keep him linked in with health services over such a long period. From the time that he was a teenager to when he was about 36 years of age, his parents had been able to keep him linked in with services while he was living with them. But by 2024, Mr Couchy was 40 years old, homeless, in Sydney, completely detached from the mental health system. He did have sporadic exchanges of text messages with his parents, including one on the 9th of April 2024 about registering his car, but there was nothing to alert his parents to just how sick he had become. They knew he was sick when he returned to live with them in early 2023, and they informed police of that when police came to their house. But Mr Couchy did not at that stage have any history of violence, and his parents were not aware of just how dark his thoughts had become towards the end of what was obviously a downward spiral, and the court will hear about that. It's not proposed that any of the dark material he was researching would be released to the public. It's enough in terms of the public interest that I have provided a broad overview in my respectful submission. On the morning of the 13th of April, Mr Couchy was sleeping outside at Maroubra. By that time, he was homeless, although he had suggested to his parents in text messages that he was in a hostel. In fact, he was not. He was far removed from any support networks. His limited contact with any other humans was largely transactional for the purposes of him getting food or drugs or getting his belongings. At 6:26 a.m. that morning, Mr Couchy packed up his belongings and left Maroubra Beach. He appears to have spent the night in the toilets or near them. He travelled by bus to the Kennards storage facility in Waterloo and arrived at 7:30 a.m. He went to a locker he had rented. The evidence in the brief indicates that he was a frequent user of Kennards facilities across various locations, and there's CCTV in that location so we can see what his movements are. Between around 8:20 a.m. and 8:30, that CCTV footage, which has been obtained with the cooperation of Kennards, depicts Mr Couchy, amongst other things, taking a knife out from a box and inspecting it. It also shows him placing the knife in and out of different bags. At 9:03 a.m, Mr Couchy left Kennards Waterloo and travelled to Bondi Junction by train. It doesn't appear that he took a knife with him on that trip. He briefly interacted with a shop attendant at a restaurant near Bondi Junction before returning to Kennards Waterloo by train. He entered Kennards Waterloo at 11:09 a.m. and proceeded to take a backpack containing a knife from his locker. From the evidence in the brief, we know that that knife was designed for utility use during World War II. It was created to replace the fighting knives of World War I. It is a knife with wide distribution and one that is mass-produced. There is only one authorised importer and distributor into Australia, but it is available for sale in Australia from various outlets, primarily Outback Supply and camping stores. The knife weighs 317 grams and has an overall length of 30 centimetres. The blade itself is 20 centimetres long. I expect Your Honour will hear further evidence about that knife and its legitimate uses and how it is sold and whether there can be any restrictions on its sale or should be. At 11:31am, Mr Couchy left Kennards, Waterloo, with the backpack containing the knife, and he travelled again to Bondi Junction by train. Shortly after he arrived, he fell to the ground outside a store on Oxford Street Mall and righted himself. It's not clear why he fell. He then walked around Westfield Bondi until around 1:15pm. He next travelled to Bondi Beach by bus, arriving at 1:25pm. We believe he then slept for a short time on the beach. At 2:10pm, he returned to Westfield Bondi Junction by bus and got off at 2:25pm. At 2:48pm, he bought food and drink and then walked around Westfield Bondi Junction, at times exiting the building. The CCTV evidence depicts him walking around the shopping centre in what appears to be an aimless manner. At 3:22pm and 29 seconds, Mr Couchy re-entered Westfield Bondi for the last time. At around 3:30pm, while Mr Couchy was on level 4 of Westfield Bondi, he headed towards the Sourdough Bakery. And it will be obvious that I'm about to refer to the first victim and some very sensitive material. As I've said, I will do so in the minimum detail possible. I'm mindful that Your Honour has a statutory function to make findings in relation to manner and cause of death, but I certainly don't need to go into any specific detail. The first and youngest victim who was killed by Mr Couchy was Miss Dawn Singleton. She was only 25 years old and a much-loved daughter, sister and fiancée. Mr Couchy walked towards the Sourdough Bakery and stood in line behind Miss Singleton. He removed the knife, that's the K-bar style USM combat knife I've just described, from the backpack, and Mr Couchy then stabbed Miss Singleton. She suffered multiple stab wounds. 2 civilians were waiting for their coffee order at the time of the attack. They immediately ran to assist Miss Singleton, helping her to lie down and using a cloth to apply pressure on her wounds. Another male was in Country Road nearby to the Sourdough Cafe when he heard the screams of others and went straight to Miss Singleton's assistance. Another woman quickly came to Miss Singleton's aid and provided initial first aid, and she called 000 to provide critical information to police. The 2 males I've already referred to who were in the line continued to provide assistance to Miss Singleton until the arrival of New South Wales Police. They were briefly interrupted by Mr Couchy re-approaching the Sourdough Bakery, and they both exposed themselves to unknown danger in order to provide care to Miss Singleton. They stayed with her even after hearing the gunshots. Another member of the public, who had been shopping with his family nearby and saw some of what occurred, rushed out to assist Miss Singleton and the men who were helping her. He armed himself with a chair that had metal legs, which was the only thing available to him, and he guarded that group in the event that Mr Couchy returned. None of those people knew each other. In the statement that one of the men who had assisted Miss Singleton wrote, he said, "The man that came out of Country Road seemed to come out of nowhere. His wife was in the Country Road store, and I later worked that out when I saw them together. That man held the neck of the chair and the legs outward. He came from the shop and said, 'I'll fight him off for you guys if he comes back.' And I thought he was really brave because he saw what we were trying to do to help the woman." New South Wales Police were the first emergency responders to attend to Miss Singleton at 3:39pm. They tried to assist her in relation to her wounds, and they opened her airway and continued CPR. They continued to assist her until New South Wales Ambulance arrived at approximately 3:50pm. New South Wales Ambulance then assessed Miss Singleton's injuries. They understood that she'd clearly suffered multiple stab wounds, and they were able to assess at that time that tragically she had passed away. The second victim was Miss Jade Young, and Miss Young, or Jade, was an accomplished architect, only 47 years of age. Mr Couchy attacked Jade at 3:33:01 p.m. near the R.M. Williams store, a short distance from the Sourdough Bakery. She suffered a single stab wound to the left of her back. As is well known by this time, Jade was with her daughter at the time that she was attacked. After the attack, her daughter used her mum's phone to contact her dad, who was also at Westfield Bondi Junction. After being notified, her dad, Noel McLaughlin, made his way to level 4. During that time, he encountered Mr Couchy. He warned others that Mr Couchy had a knife before running to find his wife. He found Jade outside the R.M. Williams store, and Noel commenced CPR with the assistance of 2 bystanders. New South Wales Police attended on Jade at 3:39 p.m, and further officers attended shortly thereafter to assist in managing her wounds and continuing CPR. New South Wales Ambulance attended on Jade at approximately 3:47 p.m, and despite their best efforts, she didn't regain consciousness, and Jade was declared to have passed away at the scene. The third victim was Ishan Cheng. She was 27 years old, in Australia, completing a Masters of Economics at the University of Sydney. On the 13th of April, she'd just finished an exam and had decided to go shopping at Westfield. Mr Couchy stabbed Ishan at 3:33 and 17 seconds outside the Peter Alexander store on level 4. Ishan was attended to by New South Wales police officers and civilians within the shopping centre. An off-duty lifeguard was shopping in Maya when he was told by an employee that someone was stabbing people outside. Shortly after that, the roller doors were shut to lock shoppers inside for their own safety. But when he looked outside of the doors, he could see that a woman had been injured, and he asked for the doors to be opened so that he could slide outside and assist. One of the persons he assisted was Miss Cheng, who was being attended to at that stage by New South Wales police officers and then ambulance. New South Wales Ambulance attended to Miss Cheng at around 3:48 p.m. They determined that she had not been conscious or breathing since their arrival, so following assessment, she was declared to have passed away. The medical cause of her death was a single stab wound to the central chest structures. Despite the fact that she had been declared to have passed away, there were subsequent attempts at resuscitation by later arriving New South Wales ambulance crews. Obviously, they were to no effect, and I will return to the further efforts at CPR made later in the opening, and it's a topic that will be explored. That's the relevance of the 10-second triage tool and what might be learnt from these circumstances, so that everybody who can be helped within the optimal period of time. The fourth victim was 38-year-old Ashley Good. Miss Good originally qualified as an osteopath before having a career change and moving into a corporate role as an executive in 2022. She was shopping at Westfield Bondi Junction with her baby daughter, whom her and her partner, Daniel Flanagan, had welcomed into the world in 2023. Miss Good was stabbed at 3:34 p.m. near AJE Athletica on level 4 of Westfield Bondi. At the time she was stabbed, as the public will understand, she was pushing her daughter in a pram. After Mr Couchy attacked Miss Good, it caused her to stumble away from the pram, and he then proceeded to stab her infant daughter, or their infant daughter, who survived the attack, incredibly. Despite her wounds, and in an act of what was tremendous and instinctive courage, Miss Good confronted Mr Couchy. She was able to defend her child and to save her child's life. Following that attack, bystanders called Miss Good, who was carrying her daughter, into the nearby Tommy Hilfiger store, and once inside the store, they attempted to apply pressure and assist her in terms of the bleeding from her wounds. Miss Good contacted her mother-in-law, who was at the shopping centre, and she made her way to assist her daughter-in-law and was there to comfort her and her granddaughter in the midst of that fear and uncertainty. New South Wales Police and Ambulance both attended on Miss Good at around 3:45 p.m. She had suffered multiple stab wounds. New South Wales Ambulance deemed that she was in a critical state and deteriorating. They evacuated her from Westfield Bondi Junction and transported her to St Vincent's Hospital at around 3:54 p.m. Upon arrival at St Vincent's at 4:04 p.m, the surgical team undertook emergency surgery, but despite those efforts, tragically, Miss Good was declared deceased at 4:29 p.m. Mercifully, and thanks to the efforts of those emergency staff and ambulance, the baby survived. Faraz Tahir was the fifth victim on that day. He was 30 years of age. Faraz moved to Australia in December 2022 and had been working in the security industry. As I've already said, Centre contracted various subcontractors for the provision of security guards at Westfield Bondi Junction, and Faraz was employed as an ad hoc security guard by Falcon Manpower Solutions, which is a subcontractor of Centre's primary security subcontractor at Bondi Junction, which is called Glad Group. That is why, of course, we have at the bar table Centre, Glad Group and Falcon. It was Faraz's first shift at Westfield Bondi Junction. Faraz was stabbed once in the abdomen by Mr Couchy at 3:34:24 p.m. At that time, Faraz and his colleague Mohammed Taha were responding to a notification of a code black from another security guard. So the pair had been directed towards the sourdough bakery by civilian bystanders. A code black situation involves a personal threat, including when an armed person is threatening to injure themselves or others. After his attack on Faraz, Mr Couchy stabbed Mohammed. Faraz was attended by New South Wales Police Force officers at 3:41 p.m. They used bandages to apply pressure to Faraz's wounds. His breathing was shallow and they found a soft pulse and continued to comfort him until paramedics arrived. Paramedics attended on Faraz at around 3:58 p.m. By that time, he was in a critical condition. They initially treated Faraz in the air bridge on level 4 of Westfield Bondi Junction. At around 4:07 p.m, they transported him by stretcher to an ambulance outside Westfield Bondi Junction. There were 2 doctors who could attend on Faraz, and they performed emergency surgery on him. Despite their best efforts, they were not able to stabilise Faraz, and he was pronounced to have passed away at the scene at 4:24 p.m. The cause of his death was the single stab wound to the abdomen. Faraz was thrust into an unprecedented and serious situation on his very first shift, but he nonetheless continued towards an unknown danger. That demonstrated great courage and selflessness on his part and on the part of his colleague. A person who was shopping nearby in the Sourdough Cafe, who's provided a statement, says that she felt relief when she saw Faraz and Mohammed heading towards the cafe. In her words, they appeared so calm, which helped me feel calm. She will remember Faraz as a hero, walking towards Mr Couchy and in danger. Others understandably ran and took shelter as they were directed to do so. But we know that there was nothing that the security guards could do to assist shoppers on that day when they were unarmed and they were facing that weapon that Mr Couchy was holding. Your Honour, the 6th and last victim was Pikria Darchia. She was 55 years old. She had arrived in Australia from her native country of Georgia in around 2012, and she came here with one of her 2 sons. Both of her sons have been involved in assisting to prepare for the inquest. Ms Darchia was stabbed multiple times by Mr Couchy at 3:34 p.m. and 50 seconds. That was around the vicinity of the Chanel boutique store where she'd run to. By that time, Mr Couchy had crossed the level 4 air bridge above Oxford Street and had headed into the northern building at Bondi Junction. After she was attacked, Ms Darchia made her way into the Chanel boutique store where she collapsed. It was apparent to the civilian bystanders that Ms Darchia's wounds were extremely serious. Witnesses inside the Chanel boutique store report that she suffered rapid blood loss and almost immediately lost consciousness. New South Wales Police were directed to the Chanel boutique store and arrived at 3:51 p.m. They couldn't obtain a pulse at that stage, but they commenced CPR in any event. Ambulance arrived at around 4 p.m. and they assessed that tragically she was unconscious, she wasn't breathing, she didn't have a pulse, and Ms. Daccia was declared to have passed away soon after. Your Honour, in addition to the attacks on each of those 6 persons who passed away, there were 10 civilians who were attacked and injured by Mr Cauchi on the 13th of April 2024. That I have not referred to them in detail in this opening is in no way meant to diminish their suffering or that of their friends and relatives, whether on the 13th of April or in the period after. Some of them were very seriously hurt and a number of them very nearly passed away. We acknowledge their trauma and its ongoing impact. With the exception of 2 of those individuals, who are content for their names to be published if required, the remaining 8 victims prefer not to be named and prefer to be referred to as pseudonyms during the proceedings where it's necessary to refer to them, and it may not be necessary. So it will be evident that in just over 3 minutes, Mr Cauchi had stabbed 16 people, 6 of whom did not survive the attacks, and others who nearly did not survive the attacks. And I think that is the last time I will have to run through those details. The investigation team have prepared plans of all 3 levels at Westfield Bondi Junction, which outlines the route that's taken by Mr Cauchi and the location of those who were injured. The plans also depict the route that was taken by Inspector Amy Scott after she arrived at Westfield Bondi Junction, including the foot pursuit that she undertook leading to Mr Cauchi, which I'll refer to shortly. Your Honour will then be able to note the distance travelled by Mr Cauchi throughout the shopping centre and the locations where each of the victims were injured, and it's spread across levels 3 and 4 of the centre. I'm going to briefly display on screen, but not on the live screen, those maps, so that parties know that those maps are available in the event that that becomes relevant when we are examining or cross-examining witnesses. So there are obviously close-ups available of these maps. They depict the movements of Mr Cauchi, the positions of victims, and the movements of Inspector Amy Scott. They might be relevant to timings, for example, of when New South Wales Ambulance or Police could get to victims to assist them. They can come down now. Your Honour, I'm about to move on to a section where I describe the background. I would draw that. I'm about to move on to the section where Inspector Scott responded to Mr Cauchi. I might do that and then ask Your Honour to break for the morning tea.
Certainly.
Based on the evidence in the brief, it appears that the first call to police was made at around 3:34 p.m. The caller indicated at that stage that there was a knife attack in Westfield Bondi Junction and that people had been stabbed. Inspector Amy Scott was the first police officer to respond at around 3:35 p.m. Inspector Scott was the tactical duty officer at the Eastern Suburbs Police Area Command on the 13th of April 2024. At the time of being assigned to the call, she happened to be in the vicinity of Bondi Junction undertaking other duties, having made her way around various police stations that morning. Inspector Scott entered Westfield at 3:37 p.m. and 14 seconds. So going back a step, she was the first unit to respond at 3:35 p.m. She happened to be in that area attending to other duties, and she entered Westfield as soon as she humanly could at 3:37 p.m. and 14 seconds. She drove her car there, jumped out, and then followed her training in terms of what was required in dealing with an active armed offender. That is, to stop the killing and to stop the dying. That's how police are trained. Without waiting for backup, she immediately entered Westfield Bondi Junction, where she was directed by civilian bystanders to go up to the escalator to level 5 because they had seen Mr. Couchy just enter the escalator. Inspector Scott then started a foot pursuit of Mr. Couchy with the assistance of the bystanders who were directing her. Inspector Scott told the bystanders to stay behind her but to show her where he had gone. There are a number of visual aids to assist to understand what happened, including police having done a fly-through video and reconstruction. I won't show them now, but I may return to them in the evidence of the officer in charge of this inquest, Chief Inspector Andrew Marks, and the evidence of Inspector Amy Scott. Inspector Scott's foot pursuit continued to the Sky Bridge on level 5. At that time, Mr. Couchy paused and turned around. At 3:38 p.m. and 12 seconds, Inspector Scott ordered Mr. Couchy to drop the knife. He didn't do so, and she drew her firearm. She then had the situational awareness and presence of mind to direct a woman who was sheltering behind a pot plant with her young children to get away from the range of fire and to run. She also moved bystanders back behind her to protect them, and she repeatedly directed Mr. Couchy to drop the knife. She was mindful of him and everybody else around her to make sure that they weren't killed by a stray bullet if she had to engage him. Seconds after she'd given those directions, Mr. Couchy then began to run towards Inspector Scott at speed and downhill. At 3:38 p.m. and 33 seconds, Inspector Scott fired 3 shots from her police-issued firearm. 2 of those 3 bullets struck Mr. Couchy in the shoulder and the neck, causing him to collapse on the floor, only 6 metres or so in front of Inspector Scott. It is uncontroversial that the quick and courageous actions of Inspector Scott on the 13th of April 2024 saved the lives of many others in Westfield Bondi Junction. The ongoing threat that was posed by Mr. Couchy was immediately stopped. After discharging her weapon, Inspector Scott reholstered her firearm and approached Mr. Couchy, putting him into the recovery position, removing the knife that was underneath him, and then working out what was required by way of CPR. New South Wales Police Force officers attended on Mr. Couchy very soon after and commenced CPR at 3:42 p.m. He was pronounced deceased when paramedics attended at around 4 p.m. I expect Your Honour will receive evidence that the use by Inspector Scott of her firearm was consistent with New South Wales Police training and policy. In the circumstances confronting Inspector Scott, there can be no doubt that lethal force was the only available option, and further evidence about that will be led through Chief Inspector Andrew Marks this afternoon. Your Honour, is it convenient to pause there for a break?
We'll take the morning adjournment and resume at 11:50.
Please the court.
Please all stand.
Thank you, Your Honour.
Got a few people coming in.
Okay, I'll just pause, Your Honour.
Probably barely enough time to get down to the coffee
Get down
shop,
to the coffee, yeah.
unfortunately.
Your Honour, while the 13th of April 2024 was a terrible day of fear and sadness, there were, as I've already alluded to, many instances of exceptional courage and compassion from those who were simply caught up in the events. They, like so many at Westfield Bondi Junction in terms of the staff, had little awareness of what was unfolding as Mr Couchy continued with the attacks. They didn't know if he was the only offender, they didn't know if he had a gun, they didn't know if this was a terrorist attack, and they didn't know what would happen next. But despite that, for many people, their focus was on helping those who had been injured. When I started preparing the opening, I had started a list of persons who could be put into that category, whose acts of selflessness were overwhelming. But there are simply too many to list, and then I fear missing those who might not have prepared a statement. So can I simply say there were so many people who were called on to do something exceptional that day who rose to the task. There were also many instances of retail assistants acting with a clear head and at least projecting calm when they must have felt anything but, while they locked down stores to protect customers. Many grabbed people from outside the store to bring them inside and to shield them from the attacker. Many of the civilians also comment in their statements on the bravery of staff in shops who took action quickly and who comforted the terrified customers or who assisted with first aid as required. In many instances, the staff who were employed at those stores are very young and they are casual employees who could never have imagined that they would have been caught up in an attack like that. And their response on the day was even more impressive in those circumstances. So staff and customers alike comment on the efforts of many others, and particularly very young people who assisted. Included amongst those people are the very young police officers who ran in after Amy Scott and who assisted to try and make sure there was no second attacker and to attend to the wounds. I turn now to the security response to the events at Westfield Bondi Junction on the 13th of April. The operator of Westfield Bondi Junction, called Centre or Centre Group, does not directly employ or otherwise provide security staff at its centres. Rather, the Centre Group enters into subcontracting arrangements with third-party security service providers. At Westfield Bondi Junction, Centre engages Glad Group to provide specialist security services. Glad further contracts or subcontracts with other companies who provide security staff on what's described as an ad hoc basis, and that includes Falcon Manpower Solutions, the company I've mentioned earlier, who provided certain of the staff on site on the 13th of April, including as I've already noted, Faraz Tahir, who was employed for the first time that day. Centre Group had policies and procedures on how to respond to an active armed offender. I've used that term previously and I'll use it again, AAO, or active armed offender. And they had policies and procedures to ensure the safety of occupants, property and Centre Group during an emergency, or to try to ensure the safety. Centre provided relevant training for its staff, and that included multi-agency exercises with New South Wales Police and New South Wales Fire and Rescue, the last one of which was held in October 2023. A key aspect of the security of Westville Bondi Junction is achieved through CCTV monitoring, and that takes place from a CCTV control room. The control room is located underground on parking level 4 at Westville Bondi Junction. I'll show a slide here because I anticipated that what went on in the CCTV room, I anticipate, will be a subject of evidence. What we see there is a snapshot or photograph of the CCTV room earlier in the day, sometime around 2 p.m. on the 13th of April. You will see, unsurprisingly, it's a room full of television screens. It's also a room which has a CCTV camera focused on it so that the movements and reactions of staff within the room are recorded. The room has changed slightly since the 13th of April 2024, and Your Honour and those at the bar table have had the opportunity to see what that looks like on an earlier view. That can come down now. On the 13th of April, 2 members of the GLAD security team were working in the CCTV control room, 1 male and 1 female. Since Your Honour has granted a non-publication order over their names, I will simply refer to them as Control Room 1 for the female operator and Control Room 2 for the male. On the 13th of April 2024, there was no requirement in any policy of the Centre Group that there be more than 1 person in the CCTV room at any one time. Evidence in the brief, including statements and that CCTV footage I was referring to, shows that Control Room 2, the male security officer, left the CCTV control room at around 3 p.m. with his supervisor to undertake training up on level 13 of the Centre Management Control Room. That left only CR1, the female security officer, who had commenced work at 6 a.m. and was rostered to stay in the control room on a 12-hour shift until 6 p.m. At 3:32 and 15 seconds, CR1 left to visit the bathroom, which is situated a few metres outside the control room. From that time on until 3:34 p.m, that is a period of some 1 minute and 45 seconds, there was no active CCTV monitoring in place at Westville Bondi Junction. It just so happened that exactly 40 seconds after CR1 left for the bathroom, at 3:32 and 55 seconds, Mr Couchy attacked Miss Singleton, the very first victim. And over the next 30 seconds, Mr Couchy attacked a further 6 individuals. A number of centre staff located in the Centre Management Control Room on level 13 were alerted to the attacks at around 3:33 and 32 p.m. So these timings will obviously be of some considerable significance during the inquest. So a number of security staff up on level 13 where the training was going on were alerted to the attacks at 3:33:32. Based on the evidence in the brief, it appears that this notification most likely came from a security guard who was located on level 5 and saw Mr Couchy attack someone near Cotton On, Lululemon and Maya, and who signalled a code black via radio. The staff in the Centre Management Control Room left that level in response to the alert, and other security staff throughout the centre also responded. CR1, the female control room operator I referred to who had been at the bathroom, is seen re-entering the CCTV control room at around 3:33:55 p.m. She was out of the room for 1 minute and 40 seconds During that time, Mr. Couchy had attacked 8 individuals, 3 of whom would die from their wounds. Active monitoring of CCTV footage did not resume again until 3:34 p.m, at around the time that Miss Ashley Good and her daughter were attacked. That the CCTV room was vacant at the time of the attacks appears to have impeded Centre's initial response. It meant that during the initial phase of the attack, where the prompt collation of information is crucial to providing situational awareness, security staff were effectively behind the 8 ball. That is, they were then playing catch-up to understand what was unfolding. CR2, the male control operator, re-entered the CCTV control room at 3:36:40. By this stage, 16 individuals had been stabbed by Mr. Couchy. Despite it being nearly 4 minutes after the attacks commenced, there does not appear to have been any communication from the CCTV control room, nor any alerts to members of the public in the centre. This initial response by Centre was also impacted by the following factors. First, based on the available evidence, I expect Your Honour to hear that the initial contact and an exchange of information between the CCTV control room and emergency services occurred approximately 10 minutes after the attack, about 4 minutes after Mr. Couchy had been shot by Inspector Scott. The security expert that has been retained by the court, Mr. Scott Wilson, has analysed this call that came from the security room and expresses the view that the quality of information supplied during that 000 call to police was not what would be expected from professional security personnel. I pause to note that, of course, other people within the centre had made 000 calls. That's how Inspector Scott came to be on the scene so quickly. But the first exchange of information from the CCTV control room and emergency services occurred approximately 10 minutes after the first attack and after Mr. Couchy had been shot dead. The Centre Management Emergency Override System, or CMEO, is something that Your Honour will hear a significant amount of evidence about in the inquest. The CMEO system displays warning on all electronic billboards present in Westfield Bondi Junction. The CMEO system is pictured here, that is the one from level 4 at the time. And I'll describe what you can see for those who can't see it from where they're sitting. On screen is a picture of the CMEO activation system located in the CCTV control room on level 4. Your Honour would note 6 buttons on that photograph, which include one yellow button that is marked Armed Offender, another button that is blue and marked Evac All, and there are other evacuation buttons for specific areas within the centre. An alarm or alert or button, whatever we call it, was not activated until 3:39 p.m, again after Mr. Couchy had been shot. It also appears that rather than using the CMEO system to warn customers of the presence of an AAO, or armed offender, security staff instead have activated the evacuation alert. So I'll say that again to be clear. Your Honour will see a series of 6 buttons going down in a row that can be pressed to activate particular warning alerts that go out throughout the centre. I expect Your Honour will hear that what should have been pressed in response to information about Mr. Couchy's attack was the armed offender alert, but instead what was pressed was an evacuation alert. And that was only pressed after Mr. Couchy was shot dead. While this error was later recognised, attempts at correcting it were unsuccessful because an evacuation override was already in place, and Your Honour will hear the evidence, of course, as to why that happened and what barriers there were to correcting it. Ultimately, of course, Mr. Couchy was deceased by the time of the alert, and fortunately there were no other offenders, but appropriately warning customers and staff is clearly one of the key functions that an operator of a commercial or public space can implement in response to an active armed offender, and it appears clear that that did not occur promptly on the 13th of April and did not occur in the way that it should have done. I'll just ask for assistance to see now slide 5. That's an image of the signage that goes up in the event of various alerts being made. In the event of an evacuation alert, you'll see there a billboard that says, "Attention, emergency evacuation. Please evacuate the centre," and gives further details. On the left-hand side in the top left is what should happen if there is an active armed offender. And it says, "Attention, armed offender, escape, hide, tell." And then, as Your Honour will hear, the operator can then give specific instructions to customers in the event of an active armed offender. The first public announcement that was made from the control room was not made until around 3:52 p.m. It occurred from the fire control room located externally to the CCTV control room. What's displayed on the screen there is a photograph of a large electrical system, and on the left-hand door we see a poster with specific instructions that are available for the control room operator to read from in the event that there is an active armed offender or evacuation is required. Your Honour will hear evidence about what the mechanisms are in this room, what announcements were made from there, that is the fire control room as opposed to the CCTV room. And I expect Your Honour will hear that one person from the control room on level 4 was directed to go there to the fire control room by another and to make an announcement. And that person did so, but they made an announcement in relation to an evacuation rather than an armed offender. That was almost 20 minutes after the start of the incident and 14 minutes after Mr Couchy had been shot by police. Witnesses within Westfield Bondi Junction recall that CR1, the CCTV control operator who was tasked with making public announcements, sounded distressed and distraught, so much so that they weren't sure whether that person had actually been taken hostage in some circumstances. As a result, there were concerns from civilian bystanders that that person might have been making the announcement under duress, and they weren't sure whether they could trust the announcement that was being made. The instructions provided in the public announcements were also inconsistent with later advice provided by emergency services and retail staff. So while the PA announced that all bystanders should evacuate the centre, New South Wales Police were advising that it was still an active situation and people should remain in place. Similarly, certain shop attendants advised bystanders that they should not evacuate around that time. That will all be the subject of evidence. A copy of the scripts for the broadcasters that are available or were available at that time is being displayed currently on screen. They were on display on both the CCTV control room and the fire control room. Your Honour will see that there is literally a script for control room operators to read, and in this case I expect you will hear that the control room operator who went there read verbatim from the script in a distressed voice, advising about evacuation in a way that may have led to confusion. Can I say again two important things so that this evidence is not misconstrued? Firstly, Mr Couchy had been shot about 15 minutes prior, so it's not suggested that that level of confusion at that stage, at the 15-minute mark, made a difference to who could have survived. And secondly, clearly, these are individuals who had never been through something like this before. So it is natural that stress in some circumstances is overwhelming, or might be. But it is important in our respectful submission to learn from the mistakes that have been made here. The third issue is that CR1 the female within the control room, called 000 at around 3:36 p.m, but it's very unclear what the timing is of the contact she made with a 000 operator. And that issue of confusion will have to be explored and explained during the inquest. Many customers and first responders reported that the emergency alarms, once activated, were extremely loud and they impaired effective communications. The impact of the volume of the alarm upon the response of New South Wales Police and New South Wales Ambulance will be explored in the evidence in the coming weeks. Communication from the CCTV control room to both security staff and first responders might appear overall, from what I've said, to have been ineffective, but that's in part exacerbated by issues faced by New South Wales Police and Ambulance first responders and the paucity of the information that they exchanged may have contributed to the declaration of Westfield Bondi Junction as a hot zone by New South Wales Ambulance, and I'll return to that issue shortly. As I have tried to make clear, the potential consequences that may have flowed from those communication issues were ultimately avoided by the quick and effective action taken by Inspector Amy Scott. However, if that had not occurred, if she had not been on the scene so quickly, there's a real possibility that Mr Couchy's attacks would have continued unabated for the further period, with some civilians and security staff unaware of what was unfolding, including the critical need for them to evacuate or locate themselves and others to safety. So the response by Centre and its security subcontractors, what could have been done differently and what changes to policies, procedures and training have been implemented as a result of the events of the 13th of April are all issues to be explored further during this inquest, and they're issues of importance to families. I expect Your Honour will hear that there have been proactive steps already taken to remedy some of the issues outlined, and we understand that interested parties are open to hearing other suggestions for improvements that emerge from a review of the evidence, particularly from the expert evidence that will be called. I come now, Your Honour, to the response of the New South Wales Police Force, some of which I've already touched on. Shortly after this tragedy unfolded, Parliament sat for the first time. And in those few weeks after, Premier Minns acknowledged the way that strangers came together to assist each other that day, and he acknowledged the extraordinary work of first responders, police and ambulance, and the crew of staff at hospitals nearby. Premier Minns spoke of the importance of acknowledging that we ask a lot of our police in these circumstances. In volatile situations, they are sent in as law enforcers, as peacekeepers, and sometimes, as he acknowledged, as social workers, but always on the front line. The Premier acknowledged that they do a complex job in very difficult circumstances and that split-second decisions need to be made almost every day. I've already explained that Inspector Scott quickly identified and shot Mr Couchy 3 minutes after accepting the assignment and just over a minute after she entered Westfield Bondi Junction. Mr Scott Wilson, the security expert, expresses his opinion that on any view this is an exemplary response. I've already said and can uncontroversially foreshadow that counsel assisting will be submitting to Your Honour that Mr Wilson's opinion would be accepted. But it wasn't just Inspector Scott who risked her life on that day. New South Wales Police attended Westfield Bondi Junction with speed. They had a number of officers on the scene. They attended soon after first notification, and the majority of those officers provided first aid or assisted with the ad hoc evacuation of civilians which was underway. Many of the first police crews on scene were junior officers, each of whom acted with enormous courage and professionalism in chaotic and violent circumstances, described by some as nightmarish. The contribution of those officers, and particularly the crews attending in the first hours, are worthy of acknowledgement and condemnation and commendation. I'll withdraw that and start it again. The contribution of those officers, and particularly the crews attending in the first hours, are worthy of acknowledgement and commendation. A number of civilians comment on how impressed they were at the time. I anticipate that the officer in charge, Detective Chief Inspector Marks, may wish to give evidence on how they can be acknowledged. They restored a degree of order and safety to the frightening scenes at Westfield Bondi Junction, and they performed first aid in extraordinary circumstances. There are areas for potential improvement that emerge from the evidence for them and for each of the first responders. One such issue is confusion amongst first responders as to whether there was the second offender present at Westfield Bondi Junction, and that's really the most significant issue in terms of the first responder issue of communication. The possibility of a second offender ultimately led to the declaration by New South Wales Ambulance that Westfield Bondi Junction was a hot zone, and that resulted in paramedics being ordered to leave the centre and stand down pending further direction. That happened at around 4:30 p.m. Fortunately, by that time, all the patients had in fact been evacuated, so it's not suggested that there was any loss of life as a result. The relevance of this is as a learning exercise in the event, and we hope there never will be another one, but in the event that a mass tragedy like this happens again. If there had been any severely injured individuals in need of urgent medical attention, any form of lockdown or restriction on access by first responders would obviously have the potential to compromise care and could have had a catastrophic consequence. Fortunately, it did not. It appears that the confusion came about in part due to poor communications between Centre Group and New South Wales Police. It'll be clear from what I've already said that by 4 p.m, Inspector Amy Scott was certain that there was only one suspect and she had shot him. Based on the evidence of the brief, it appears that a review of that information occurred inside the CCTV control room based on the CCTV footage. By around 4 p.m, I expect the evidence to show centre staff and security had ascertained that there was only one suspect. However, there was no effective mechanism in place for the sharing of accurate and timely information between the agencies on the ground in that terribly confused state. Better communication between New South Wales Police and the Centre Group staff may have avoided that confusion, and that's what parties have been looking at over the last year as we piece together these events to see what can be done to work together to avoid it. Related to this, there were also issues concerning the coordination between Centre, New South Wales Police and New South Wales Ambulance and the sharing of information that it's important to learn from. In particular, I expect Your Honour to hear that there was confusion as to the location of an overall incident command post to be used by both New South Wales Police and New South Wales Ambulance, with New South Wales Ambulance staging at Oxford Street between two Westfield buildings and the police staging a command post in a loading dock in Grey Street off Bronte Road. There was also confusion on the part of New South Wales Ambulance as to the address of the police command post once established, and it was later necessary to move the command post due to reception issues. It was ultimately situated within Westfield. Likewise, there was confusion about the potential identification of a second offender and poor communication between emergency services on the ground in relation to that issue. None of that is said to blame individuals. We can only imagine, sitting here with the benefit of a hindsight lens, how confusing and difficult that scene must have been to process. But that is exactly why we take this opportunity to try and assist those groups to learn from it. Police radio broadcasts at 3:52 p.m. and 3:58 p.m. suggested that police had been provided with intelligence that indicated there may be a second offender. As at 4:07 p.m, some police still held concerns about the possibility of a second offender, which led to a New South Wales police officer being dispatched to the CCTV control room to review the footage and confirm the total number of offenders. At around 4:15 p.m, New South Wales Police Public Order and Riot Squad members acted on intelligence which suggested that there might be a possible offender on the rooftop car park at Westfield Bondi Junction. And it appears from the brief of evidence that confirmation of one offender was provided to police at around 4:30 p.m. in spite of that confusion. Despite that, New South Wales Ambulance still held on to their concerns about the presence of the second offender at 4:30 p.m. and the period thereafter, and that resulted in a hot zone. Even just an outline of that information will perhaps convey the level of confusion with the multiple numbers of agencies and staff who were trying to get across the information and make sure, of course, that a critical mistake was not made at that time. Your Honour, I expect the evidence to show that it took nearly 2 hours for the first multi-agency tactical command meeting to take place with senior police, ambulance and centre staff. That took place at around 5:30 p.m. In his evidence, the expert security advisor, Mr Wilson, expresses the view that that is too late and that had multi-agency meetings occurred earlier, the subsequent confusion that punctuated the initial response about a possible second offender may have been avoided. Importantly, however, it doesn't appear, at least based on our review of the brief of evidence, that any aspect of that confusion affected the survivability of any individual on the 13th of April. We hope that any recommendations that emerge from this inquest will be relevant to saving lives in the future. New South Wales Ambulance, if I may turn to them now, received the first call for assistance at 3:34 p.m. Just over 2 minutes later, the first ambulance crews were assigned. The first crews arrived at Bondi Junction at 3:42 p.m, 8 minutes after they had been notified, 11 minutes after the attacks by Mr Cauchi. There were 17 crews present at Westfield Bondi Junction, and over the first hour of the incident, a total of 47 ambulance resources were assigned to the centre. So there's no disputing, in my respectful submission, that the response was prompt and the first responders at the scene acted with courage in what was still an uncertain and unfolding and volatile situation. Based on the evidence available, once they arrived, there was more than sufficient ambulance resources available. Commendably, despite the volume of resources that had to be deployed at Westfield Bondi Junction, it appears that that didn't result in any adverse impact to New South Wales Ambulance broader metropolitan business as usual operations, because of course there will be other people around the state needing emergency care during that time. As with both Centre and New South Wales Police, whether aspects of the response could be improved, and largely from an operational management and communications perspective, will be the focus of the inquest. That doesn't detract from the actions of New South Wales Ambulance staff present on the 13th of April 2024, and we're conscious that some of those ambulance officers will be watching the live stream or attending court because they think of the individuals who they were working with on that day, doing everything that they could to try and save their lives. The events of the 13th of April are in all probability, hopefully, a once-in-a-career incident. And the professionalism and dedication of the attending New South Wales ambulance crews, as well as the call takers and dispatchers in the ambulance communication call centre, is exceptional, worthy of commendation and certainly gratitude on behalf of the community. Notwithstanding that, it's likely that evidence will indicate there were issues at a higher level of the New South Wales ambulance response and important lessons to be learned. The two most senior initial New South Wales ambulance attendees were Ambulance Officer 1, who has been given a pseudonym, and Mr Brett Simpson. They faced a highly complex scene with patients spread over 3 levels of this very busy shopping centre, with the added difficulty of security barriers and screens on the majority of shop fronts. Compounding this was the very large number of frightened and shocked civilians and an extremely loud evacuation alarm system, which was hampering communications. The inquest will explore the New South Wales Ambulance command and control structure in that critical first hour of the incident and thereafter. I expect it will indicate some confusion as to who was undertaking the various roles specified in the New South Wales Ambulance Major Incident Response Plan, and ultimately who had overall leadership at the scene. As a result, there may be evidence that there was, in effect, some form of leadership vacuum at the scene during the critical first hour, notwithstanding the best efforts of all personnel on the scene. The expert evidence, I anticipate, will suggest that there was a lack of clear overall incident command, which contributed to the interagency communication issues, and that there are important issues to learn from in that regard. In particular, based on unidentified New South Wales police intelligence, which I've already alluded to, at around 4:01 p.m, Inspector Simpson reported that there was a second armed offender. On that basis, on the basis of this and other communications, there was the declaration of the hot zone that I've referred to earlier, and as a result of that, no ambulance personnel were permitted to re-enter the centre after 4:30 p.m. By that time, that is, by the time it was declared a hot zone, there were sufficient resources in the centre to attend to those who had been wounded. Given the issues with communication amongst the paramedic crews, the deafening alarm at that time and the layout of the scene contributed to the difficulty of doing a complete scene sweep. And those difficulties appear to have contributed to inefficiencies in the triaging of victims and those injured at Westfield Bondi Junction. There doesn't appear to have been a clear application of the triage sieve system, with arriving crews doing a combination of triage and then attempting to provide treatment to the victims in the centre. That's generally contrary to triage practice and procedure. It also appears from the evidence that not all New South Wales ambulance responders carried triage tags to indicate that a patient had already been assessed. And that meant that some patients who had already passed away were then re-triaged by crews. And that was not the best use of valuable resources, and I've referred to that happening in the case of Ms Cheng. On the issue of triage process and procedure, Dr Philip Coburn, a UK consultant in emergency medicine with a specialty in pre-hospital care, will give evidence in week 4 about what's been introduced in the UK and Europe by way of a 10-second triage tool. That's a new streamlined triage process which allows first responders from any emergency service to effectively triage patients during a mass casualty incident. And that's anticipated to be a fertile area for future recommendations. It is perhaps a function of the fact that Australia has had so few mass casualty attacks that we are learning more about the 10-second triage rule and how to implement it in this country now. In Europe, and in particular the UK, of course, sadly, they have had to deal with this much more than we have, and there are important lessons to be learnt from what they've experienced. One clear question that emerges from that summary is whether these command and communication issues adversely impacted on treatment received by any victims on the day. I've referred to Dr Stefan Mazur, an expert who's been retained. He's an emergency physician at the Royal Adelaide Hospital. Dr Mazur expresses his expert opinion that the injuries suffered by each of these civilians who passed away were not survivable. However, his opinion is caveated in respect to Faraz, whose injuries are expressed as being probably unsurvivable. So what I mean by that is, in spite of the communication issues that we will learn from, for the most part, it is unlikely, extremely unlikely, to have made a difference on the day. However, Dr Mazur observes that Faraz was treated by New South Wales Ambulance approximately 13 minutes after their arrival on the scene and 24 minutes after he was stabbed. Prior to Faraz being assessed by New South Wales Ambulance, Miss Good's daughter had been seen by 3 separate teams, Jade by 2, Miss Cheng by 2, and Miss Good had been extricated along with her daughter. Dr Mazur says that if Faraz had been triaged earlier and identified as critical and an arriving paramedic crew had been directed straight to him, this may have allowed for earlier intervention and extrication. Although Dr Mazur ultimately concludes that Faraz's injury was probably unsurvivable, the potential for earlier treatment is a matter that will be explored during the inquest. I reiterate here, and I've perhaps done it too many times, but I'll do it again here, that I reiterate that the purpose of this inquest is not to blame individuals or organisations who were obviously doing the best that they could, but the team assisting has to look at these issues with a view to what can be learnt. We appreciate that all of those ambulance crews were dealing with an unprecedented situation, and it is anticipated that we will submit that they did the best they could in those circumstances. But we will identify what, if anything, could have been done differently for the purposes of identifying lessons that will assist with any future responses. And for that reason, it's hoped that Dr. Coburn can attend in person in these proceedings and talk us through the 10-second triage rule and how it can be introduced. I turn now to the last major topic, which is Mr. Couchy's mental health and the management of his condition prior to the attacks. For over 18 years, Mr. Couchy had been successfully treated for his schizophrenia. It is perhaps part of the terrible tragedy of what then unfolded in 2024. His condition was appropriately managed, he was supported by his family and clinical care team, and he was voluntarily taking medication from when he was about 17 to 36 years of age. And he was regularly attending his appointments as directed. However, by April 2024, he had been effectively unmedicated for nearly 5 years. He had no consistent or formal engagement with the mental health system or the health system more generally, and he was effectively lost to follow-up, the consequences of which were the catastrophic events of the 13th of April. How that happened and what could have been done differently are key issues in this inquest. Importantly, Your Honour, the inquest does not seek to stigmatise persons living with mental illness, in particular with schizophrenia. And we know that most people with schizophrenia, and there are tens of thousands of them in our community, most people with schizophrenia will never commit an act of violence, let alone a serious act of violence. But it is an unavoidable fact that a small number of homicides are committed by people with psychotic illnesses. The parents of Joel Couchy had loved and cared for him all his life, and I expect the evidence to show that they were absolutely shocked when they realised on the 13th of April that he had committed these terrible acts of violence and had taken the lives of innocent people. As soon as they saw images on the television of the person who appeared to be the perpetrator, they contacted police by telephone to identify to police that they believed that that was their son. They then cooperated fully with Queensland and New South Wales Police in providing them with all the details about their son. There can be no doubt about their efforts to provide him with support and care and to deal with an incredibly challenging and demanding illness throughout his life. We empathise with their suffering and we're grateful for their engagement in the inquest to date. Mr. Couchy was born on the 13th of June 1983. He grew up with his family in Toowoomba, Queensland. He had what can only be described as a relatively normal childhood with parents who loved and cared for him. Around the age of 14, however, his family began to notice changes in his behaviour and personality. He's reported to have experienced delusions, hallucinations, thought disturbances and disorganised behaviour. He became aggressive. His family sought treatment in the mental health system. Between the 26th of January and the 23rd of February 2001, Mr. Couchy was admitted for the first time to a mental health hospital. He was admitted to Toowoomba Hospital following a particularly acute psychotic episode. At the time of admission, Mr. Couchy described to doctors that he had hallucinations. He reported seeing and feeling demons entering his body, feeling as though his movements were controlled and that people were inserting thoughts into his mind. He believed that he was being followed. The initial diagnosis was paranoid psychosis and schizophreniform disorder. Around 6 months following that first admission, he was diagnosed with schizophrenia. And it will be obvious that some of those ideations had clearly returned from around 2022. Schizophrenia generally requires lifelong care and treatment, including, I expect Your Honour to hear, lifelong use of antipsychotic medication. From 2001 to 2012, Mr Couchy received that care in the Queensland Public Health System from the Toowoomba Mental Health Service. So I'll repeat that again. From 2001 through to 2012, Mr Couchy received that care in the Queensland Public Health System from the Toowoomba Mental Health Service. He was first trialled on an atypical antipsychotic medication called olanzapine from around January or February 2001. Clinical records indicate that despite consistent treatment and an increasing dose of olanzapine, his psychotic symptoms gradually returned. So he was further trialled on risperidone in around mid-2002 to around October 2002. And I expect Your Honour to hear from the psychiatric experts that there does have to be a period of trialling various medications when persons with psychoses are first put onto a regime. In October 2002, Mr Couchy was once more admitted to Toowoomba Hospital to manage a change in his medication, this time from risperidone to clozapine. Mr Couchy was prescribed clozapine from October 2002 to around June 2018. From October 2002 to around June 2018, so nearly 14 years. Based on the view of the experts retained to assist Your Honour, Mr Couchy's treatment with clozapine is an indication that he suffered from what is sometimes called treatment-resistant schizophrenia. Olanzapine is often an effective and high-risk antipsychotic with significant and potentially severe side effects. So as a result, that medication is only used in people with schizophrenia where other antipsychotics are ineffective. As stated in the expert report of psychiatrist Professor Heffernan, which will be tendered shortly, olanzapine is generally considered, along with other aspects of treatment, care and monitoring, to be lifelong medication. If treatment is ceased, there's a real risk of relapse and readmission. Mr Couchy's clozapine dose was steadily increased until it reached 575 milligrams a day in June 2003, by which stage his auditory hallucinations ceased. In around July 2007, Mr Couchy's treatment was augmented to include Abilify. Around this time, he was also diagnosed with excessive compulsive disorder. Mr Couchy maintained his use of psychotropic medication whilst treated in the public health system. In December 2011, his clozapine dose, which had been increased at a maximum of 600 milligrams a day, was reduced to 550 milligrams, and that was because there were concerns of oversedation. He was discharged while he was on that amount in March 2012, that is, discharged from the public system to a private psychiatrist who was based at a private clinic in Toowoomba. Prior to discharge, Mr Couchy was noted as being a particularly good candidate for transfer of care to a private setting, given that he had at that stage high levels of insight into his illness, his compliance with treatment, the absence of significant risk factors in the course of his treatment, and his considerable family support made him a candidate for private care. At that time in March 2012, his circumstances were relatively stable. I've already mentioned his supportive parents. He had accommodation. He was attending university. He was not misusing substances critically. He adhered to his treatment, and he hadn't demonstrated any high-risk behaviours such as violence to himself or others since he had commenced treatment. So all those issues were critical in the decision to discharge him to private care. The private psychiatrist who then took over care at that stage was Mr Couchy's treating psychiatrist from March 2012 until February 2020, when, as I'll come to shortly, he moved to Brisbane. Mr Couchy saw her, that is, that private psychiatrist, approximately once per month in a Toowoomba private clinic. He also saw nurses who acted as his clozapine coordinator. Those appearing on behalf of the psychiatrist and the two nurses have asked at this stage for a non-publication order over their names. Your Honour is not prepared to grant a permanent non-publication order at this time, but an interim non-publication order has been granted and will be revisited after the panel of psychiatrist experts have given evidence, and that's so that the evidence can be put in context and the views of experts properly canvassed so that they are not misunderstood. For the purposes of this opening, I'll refer to her for now as Psychiatrist A. Over the period that Mr Cauchi was treated at the private centre, his clozapine dose was gradually reduced until it ceased altogether in June 2018. Based on available medical records, the reason for his clozapine dose being reduced appears largely to be related to his concerns of over-sedation. He reported that the medication made him feel tired. He also expressed a desire to decrease his reliance on medication. Based on the available evidence, it appears that Mr Cauchi was otherwise compliant with his clozapine during the entirety of the period that he was prescribed it. Ultimately, it was determined to reduce his dosage, and that was supported by a second opinion from a psychiatrist in 2015 who had treated him in the public system. He was monitored closely for a period of time as the tapering down process for the clozapine continued until it was ultimately ceased in June 2018, as I've already noticed. In around June 2019, he further ceased treatment with the other drug I mentioned, Abilify, and thereafter he never took psychotropic medication again. So, to repeat, he stopped all psychotropic medication in June 2019. Clearly an important issue in this inquest is the decision to reduce and ultimately cease his medication, first with clozapine and then with Abilify. I've already noted that expert evidence suggests that individuals who have been diagnosed with treatment-resistant schizophrenia face an increased risk of relapse and readmission and adverse impacts on recovery when clozapine treatment is ceased. In Mr Cauchi's case, his cessation of treatment unfortunately coincided thereafter with him exiting the mental health system altogether. He was effectively lost to follow-up from early 2020, and it is to that issue that I now turn. Evidence in the brief suggests that from October 2019 to February 2020, so obviously shortly after he ceased all psychotropic medication, Mr Cauchi's mother raised concerns on several occasions with the private Toowoomba clinic about her son being unwell and the risk of possible relapse. I expect the evidence to show that that included Mrs Cauchi, Joel's mother, expressing the concern that he was again hearing voices and that she had found some notes he made which suggested that he believed he was under satanic control. In the period November to December 2019, Dr A provided Mr Cauchi with prescriptions for Abilify and then something by the name of Rexulti, which is another atypical antipsychotic. The medication records suggest that Mr Cauchi's mother hoped that he would restart his medication, but that Mr Cauchi had said he wasn't keen to do so because he didn't want the dysphoric effects that he'd experienced in the past when the medication he was taking impacted on him. Mr Cauchi was advised by Dr A to self-determine whether he should start taking the medication again that she'd provided on script, and the evidence suggests that Mr Cauchi did not do so. So an important issue for this inquest is whether the warning signs disclosed to Mr Cauchi's psychiatrist, Psychiatrist A, in late 2019 and early 2020 should have been acted upon in a more assertive manner, including whether more rigorous psychiatric assessment was required, which may in turn have prompted a reconsideration of Mr Cauchi's management plan, or alternatively, a referral for a public mental health service assessment. I've said that Mr Cauchi was effectively lost to follow-up after early 2020. There was sporadic one-off contact with two different psychiatrists in Brisbane in the following year, but it didn't result in any ongoing supervision. On the 17th of February 2020, Dr A was in Caloundra and Mr Cauchi attended an appointment with her by Skype. In mid-March 2020, Mr. Couchy had moved to Brisbane. He tried unsuccessfully to join a Skype session with Dr. A, but he was unable to do so because his Skype wasn't working. At around the same time, staff at the private Toowoomba clinic became aware that Mr. Couchy had moved to Brisbane and was therefore, as they saw it, no longer eligible for Medicare Skype appointments or nursing support. Mr. Couchy did not want to attend face-to-face appointments because of his difficulty travelling from Brisbane to Toowoomba. And Your Honour, and those listening will recall that that was also around the time, tragically, of the onset of the COVID pandemic, which made it difficult to travel. So as a result of all those issues, the private Toowoomba clinic cancelled the appointment with Mr. Couchy. The private clinic staff contacted Mr. Couchy regarding a referral to his GP in Brisbane. Mr. Couchy said he didn't yet have a GP in Brisbane and he would let them know when he did. In the absence of a Brisbane-based GP, Dr. A discharged Mr. Couchy into the care of his long-term Toowoomba-based general practitioner. And that discharge signified a rather sudden end to Mr. Couchy's treatment by Dr. A after what had been consistent treatment and attendance over an 8-year period. Clearly, the inquest will consider whether there was a missed opportunity by Dr. A or anybody else to ensure that Mr. Couchy had continuity of psychiatric care no matter where he was located. And Your Honour will, of course, hear from Dr. A in that regard and what were the limitations for her of what she conceived of what she could do. The inquest will consider whether, in circumstances where Mr. Couchy had already left to Toowoomba, I'll withdraw that and start again. The inquest will consider whether, in circumstances where Mr. Couchy had already left Toowoomba, it was appropriate to discharge him into the care of a Toowoomba-based GP instead of a Brisbane-based GP. And the inquest will consider whether or not that clinic properly took into regard the concerns that had been expressed by Mr. Couchy's mother over a period of months. There's no reference in the available medical records that would indicate that Mr. Couchy attended any subsequent appointment with the Toowoomba-based GP following his discharge by Dr. A. That's perhaps not surprising given that he'd moved to Brisbane. There's no mention of a recall of Mr. Couchy by the Toowoomba GP, other than a recall letter dated the 11th of May 2020 from the practice. That was in relation to blood testing. But that's an unsigned letter addressed to somewhere in Toowoomba, not Brisbane. Records were later transferred from the private psychiatrist in the clinic in Toowoomba to other practitioners, but much later in time and in response to requests from those practitioners for the records. I expect Your Honour to see that there's no evidence of a particular plan regarding continuation of Mr. Couchy's mental health care or transfer or care records to another GP or psychiatrist. So the steps that could have been taken by the Toowoomba GP practice will also be an issue to be explored at the inquest. In short, what ultimately occurred is that when Mr. Couchy moved from Toowoomba to Brisbane, he wasn't taking any antipsychotic medication, and there was no specific plan that we can locate for follow-up of his mental health care. He had left behind his strong support networks in Toowoomba, and in Brisbane he was in effect on his own. After Mr. Couchy ceased receiving treatment at the Toowoomba Centre in early 2020, the available evidence indicates that he received limited mental health care, whether from a GP, psychiatrist or anybody else. The expert evidence suggests that Mr. Couchy's mental health condition was not effectively treated or managed from that time on. After discharge from Dr. A, Mr. Couchy saw 2 psychiatrists in Queensland, but primarily because he was requesting that they provide a short report in support of an application for a gun licence, which is an issue that I'll return to shortly. On the 26th of November 2020, Mr. Couchy saw the first Brisbane-based psychiatrist, Dr. B, which is a pseudonym at this point in time, although I note that that's only an interim order for a non-publication. Dr. B was at a Medical Centre in Brisbane, and Mr. Couchy left the appointment that he had made with Dr. B before that psychiatrist could even complete the assessment. Almost 2 months later, on the 18th of January 2021, Mr. Couchy saw a second psychiatrist, who I'll call Dr. C, but noting again that it's only an interim non-publication order at that stage. He was at the Oxford Street Clinic in Brisbane. Mr. Couchy was referred to that clinic by his treating GP, who requested an assessment and follow-up by a psychiatrist for management of schizophrenia. The psychiatrist then was told, that is Dr. C, that Mr. Couchy had been diagnosed at the age of 17. It was noted that Mr. Couchy moved from Toowoomba to Brisbane and so was unable to continue to see his long-term psychiatrist, Dr. A. And on the basis of the information provided by the GP, it was suggested that Mr. Couchy was at that stage in remission and did not have active symptoms of schizophrenia and was not on any psychiatric medication at the time. Obviously, that contrasts with what Mr. Couchy's mother had said at the end of 2019. At that consultation on the 18th of January 2021, Mr. Couchy advised the doctor that he was seeking a psychiatric review for the purpose of a medical fitness so that he could visit a gun range and practice target shooting under supervision. It appears that Mr. Couchy was able to explain his psychiatric history to the psychiatrist and was largely open about it. He reported, for example, that he'd been hospitalised in 2000 at the Adolescent Psychiatric Unit at Toowoomba Hospital following a psychotic episode where he experienced tactile hallucinations secondary to significant use of cannabis for over a year. It was clear that he explained that following his admission to Toowoomba Hospital, he was then commenced on antipsychotic medication, initially on clozapine and then aripiprazole or Abilify. Mr. Couchy stated to Dr. C that he remained asymptomatic in his view and in remission during the period that followed. Mr. Couchy reported that he had been off the Abilify for the past 18 months and had not suffered a relapse in psychotic symptoms. And he told Dr. C that he wasn't on any medication at all. Mr. Couchy denied any recent or current drug use and said that his last drug use was prior to the hospital admission in 2000. He denied any acute medical problems or allergies other than bee stings and reported no known family history of schizophrenia. I pause to note that that last statement was not correct. Dr. C undertook an assessment of Mr. Couchy. I expect, Your Honour, to hear evidence that he didn't think that Mr. Couchy displayed any thought disorder or psychotic symptoms in that one interaction that Dr. C had with him in his clinic. His mood was noted to be euthymic or stable. So the doctor recorded that he was a stable mental state with a positive, stable mood. Mr. Couchy reported no hallucinations, no psychotic symptoms, no problems with memory or functioning, and normal appetite and sleep. He denied thoughts of suicidal ideation or self-harm or thoughts of harm to others. Dr. C did notice that Mr. Couchy had some twitching of the mouth, but Mr. Couchy told Dr. C that was due to nervousness. This is, of course, a significant period of time prior to the Bondi Junction attack. This was the 18th of January 2021. With respect to the application for a gun licence, Mr. Couchy apparently told Dr. C that he didn't plan to purchase a gun, but only intended to practice target shooting at a gun range which would be supervised. He also mentioned that the previous time he visited a gun range was when he was 25 years of age in 2001. Dr. C obtained Mr. Couchy's consent to obtain collateral history from the Toowoomba psychiatrist, Dr. A, who I've already mentioned, and that was in relation to his psychiatric history, medication history, and other treatment and associated risk. And Mr. Couchy signed a consent form which enabled Dr. C to contact Dr. A. I expect Your Honour to hear evidence that the Brisbane-based psychiatrist that I'm just mentioning, Dr. C, who saw Dr. Couchy for this purpose of saw Mr. Couchy for Mr. Couchy's request of getting a gun licence, saw him only on that one occasion. And he determined that Mr. Couchy's risk to himself and others was low. In those circumstances, he did not consider it necessary to provide him with a follow-up appointment or any ongoing treatment because Mr. Couchy was not on any psychotropic or psychiatric medication that would have required follow-up. And I expect that to be an evidence that is of significance to Your Honour. Following the consultation, Dr C did indeed obtain the collateral information sought from Dr A in Toowoomba. It confirmed that clozapine was ceased in around June 2018 and Abilify ceased after a review in June 2019. It confirmed that according to Dr A, Mr Couchy had not suffered a relapse in psychotic symptoms following ceasing Abilify for approximately 18 months prior to the review. After receipt of that collateral information from Dr A, Dr C wrote to Mr Couchy's Brisbane-based GP and recommended that Mr Couchy have 6 monthly reviews to monitor for mental state, even though he is currently asymptomatic. It's unclear who it was intended should perform those 6 monthly reviews. That is, was it a psychiatrist or was it a GP or both? And it's unclear who it was intended or recommended that the relevant psychiatrist or GP should be, and Your Honour will no doubt hear further evidence about that. In any event, that recommendation didn't result in any follow-up action. Dr C did not receive any further correspondence from Mr Couchy or his Brisbane-based GP and was not involved in any follow-up care or treatment. Mr Couchy had been referred to these psychiatrists by a Brisbane-based general practitioner who first saw Mr Couchy in May 2020 via a telehealth consultation. And Mr Couchy continued to attend on that GP periodically, with the final consult being the 30th of April 2021. And after that, Mr Couchy didn't see a doctor for 2.5 years. On the 20th of January 2021, following up from what I've just said about the interest in obtaining a gun licence, the Brisbane-based psychiatrist provided a report in support of Mr Couchy's application for a gun licence, which was then submitted by Mr Couchy on around the 25th of January 2021. In response to a letter dated the 8th of February 2021 from the Queensland Police Service Weapons Licensing Branch, that psychiatrist, Dr C, provided a further report dated the 19th of February, in which he confirmed that Mr Couchy was, at that stage, in his view, a fit and proper person to be issued with a weapons licence. And Mr Couchy was ultimately issued a state of eligibility by the Queensland Police Service a statement of eligibility. A statement of eligibility supports a condition required to accept a person for membership to an approved pistol club under the Weapons Act. A statement of eligibility is not a weapons licence, and nor does it allow for the purchase of a weapon. A statement of eligibility is not a prerequisite for holding a weapons licence. But with that in mind, the interest shown by Mr Couchy in obtaining access to firearms, even at a pistol range, whilst untreated for schizophrenia, raises questions regarding the scrutiny of any applicant for any form of firearms permit, where the applicant has a history of involuntary psychiatric hospital care, particularly for the sort of treatment-resistant schizophrenia that Mr Couchy was suffering. And I anticipate that Your Honour will hear evidence about that from our psychiatric panel. The available evidence suggests that Mr Couchy did not follow through with a gun licence, and that is very, very fortunate, because the evidence on Mr Couchy's iPhone and his internet searching suggests a very significant deterioration of his mental health steadily from the time that he was unmedicated, and a significant deterioration around this time. Interactions with a psychiatrist in 2021 may have provided an opportunity to re-engage Mr Couchy in treatment and care in a proactive manner. And the extent to which these possible opportunities were missed by both Doctors A and C will be explored in this inquest. As with other witnesses, those doctors are encouraged to be forthcoming with this court, to give evidence in a way that is full and frank and genuinely directed to assisting with the systemic issues that arise in this case with a view to saving lives in the future. By late 2023, Mr Couchy was back in Toowoomba. On the 13th of November that year, he saw a GP from North Point Medical in Toowoomba. I've just been given a note about the time. Would Your Honour permit me to continue? I have only, I think, 10 minutes and then we can finish and break for lunch. By late 2023, Mr Couchy was back in Toowoomba. On the 13th of November that year, he saw a GP from North Point Medical in Toowoomba for the first and only time, and that was solely for the purpose of consulting about a driver's licence. His driver's licence was expiring and he was required to see the general practitioner. So it would be evident that Mr Couchy was not going to his GP for mental health care at that time. The appointment with the GP at that stage was not cursory. The doctor obtained additional information from Mr Couchy, who disclosed his diagnosis of schizophrenia. The GP spoke with Mr Couchy's mother and undertook a mental state examination. He determined that according to that brief interaction, there were no acute issues that appeared to him to require immediate attention, and he ultimately completed a medical certificate noting that Mr Couchy should retain the M condition on his licence. That is to say that following that consultation, the GP wrote a letter to Dr A, who we all know was the long-term treating psychiatrist in the clinic in Toowoomba, seeking further information regarding Mr Couchy's mental health history, and that was subsequently received. In that letter, the GP stated that Mr Couchy was not frankly psychotic at that point. It noted that he'd been off his medication for a number of years and that GP thought he had not had a major relapse. And he said that he could not find a reason why he required an ongoing M on his licence, to be honest, in his words, given that he wasn't medicated. I just ask Your Honour to note the date here. That was the 13th of November 2023, and the relevance of that date is that I'll come shortly to an interaction that New South Wales Police had around that very time with Mr Couchy at his home address, which clearly shows that Mr Couchy was experiencing significant mental health issues at that time and had been in the lead-up. As the last occasion on which Mr Couchy was seen by a medical practitioner about his mental health, and just prior to the interaction with Queensland Police, and 5 months prior to the terrible events at Bondi Junction, the circumstances of that presentation to a general practitioner will again be explored in the hearing. Yet again, it might have been an opportunity for the GP, or indeed Dr A, to recommend a comprehensive review of Joel Couchy at that time, given the possibility of his mental health having deteriorated, given he had not been medicated for so many years and had had such a significant condition chronically to start with, and particularly given the concerns that had been expressed by Joel Couchy's mother in 2019 and early 2020. The expert psychiatric evidence to date emphasises the importance of allowing persons with mental health conditions the autonomy to manage their own lives, medical conditions and medications. But at the same time, I expect the court to recognise that we also need a system that can respond appropriately when a person becomes unwell and potentially constitutes a risk to themselves or others. The interaction or intersection between autonomy, human rights, self-determination and compulsory treatment is a vexed topic, but it is so important that we get the balance right. The problem Mr Couchy faced from 2020 onwards was that no health practitioner held responsibility for his ongoing care, or didn't obviously hold responsibility. And so no person was in a position to re-evaluate the appropriateness of previous treatment decisions, including the fact that his antipsychotic medication had been ceased. This emphasises the importance of providing optimal clinical handover of a patient, particularly a patient like Mr Couchy, to reduce the risk that someone like him suffering from a chronic mental health condition will be then lost to follow-up after the transition of care. and thereafter doesn't get the care that they need or that the community needs them to get. Likewise, opportunities for reintegration into the mental health system, including on the part of ad hoc or irregular health practitioners who step in, should always be actively considered, particularly where a parent or close relative is expressing concern. The lack of access to a detailed clinical history was an issue for the practitioners seeing Mr. Couchy after 2019. Various clinicians did seek additional history, but they weren't able to readily access it, or at least the entirety of it. And this inquest will consider what alternatives there may be to assist. One option proposed by the experts is a single record permitting all involved in care, whether public, private or non-government organisations across all states and territories, to access medical records in these circumstances. I come now then to the interactions with Queensland and New South Wales Police. There were several interactions as between Queensland and New South Wales Police and Mr. Couchy after he ceased treatment in 2019 and before the events of the 13th of April. The interactions with Queensland Police included fare evasion in August 2020, July 2021 and October 2022, being stopped due to erratic driving in October 2020, November 2020 and September 2021, and street intercepts by police in Toowoomba in August and September 2023. He was also wandered, that is Mr. Couchy was wandered with a handheld metal scanner on the Gold Coast in December 2023, but he was not carrying any knives at that time. Mr. Couchy had one interaction with New South Wales Police on the 21st of July 2023 when he was found sleeping rough in the Sydney CBD, and a bystander had contacted police because of concerns for Mr. Couchy's welfare. Police checks at that stage revealed that he had a warning in relation to knives, mental health and self-harm in Queensland, and that resulted in Mr. Couchy being subject to a general search, but no dangerous knives or other items of interest were identified at that time, and there were no further interactions with New South Wales Police. The inquest will explore whether certain of those interactions were missed opportunities to see if anything could have been done differently. In particular, the inquest will look at how police first responders deal with those who might be suffering mental health conditions and what resources they have at their disposal to consider whether or not there should be more to assist them deal with persons in the community with mental health issues. On the 27th of May 2021, Queensland Police were called to Mr. Couchy's unit in Brisbane following reports of a male screaming and someone being hit. Police attended and spoke to Mr. Couchy, who told them he was frustrated with his fridge because it was broken. There was no offence detected at that time, so I'll pause to note this is dealing way back in May 2021. There was no offence detected, but a caution was added to the Queensland Police system stating that he was a diagnosed schizophrenic who doesn't take medication, quote unquote. On the 27th of July 2022, a Crime Stoppers report was received regarding Mr. Couchy's contact with a high school in Toowoomba and his attendance at the school's sports centre in an attempt to spectate a swimming carnival. So that's almost 2 years prior to Bondi Junction. The school took swift action and he was not permitted to attend. The most significant interaction with Queensland Police came on the 8th of January 2023 when officers of the police attended the home of Mr. Couchy's parents in Toowoomba, where Mr. Couchy was then residing. Your Honour, I misspoke earlier when I said that police had attended in November 2023. This is the 8th of January 2023, and it's clear that in this interaction Mr. Couchy appears to be mentally disturbed or mentally unwell. And Your Honour will note that it's then in November 2023, much later in that year, that a GP on a snapshot of Mr. Couchy assesses him to be presenting as not unwell, which I anticipate submitting shows the importance of having a longitudinal understanding of Mr. Couchy's mental health and to ensure that anybody doing that snapshot review has access to those records. So on the 8th of January 2023, officers from Queensland Police attended the home of Mr Couchy's parents in Toowoomba, where Mr Couchy was then living. Mr Couchy had accused his father of stealing his military collector knives. Andrew Couchy, Mr Couchy's father, had taken the knives, effectively confiscating them because he was concerned about his son having access to them. The interactions between Queensland Police and Mr Couchy are captured on body-worn video, and I anticipate that they will be played during the inquest. During the interviews with police at that time, captured on body-worn, both of Mr Couchy's parents state that in their opinion he's mentally unwell, that he needs treatment, and that he's been observed, for example, to be making odd noises, banging his feet and slapping his face, and that he was seemingly distressed by auditory hallucinations in the early hours of the morning. On one occasion, Michelle Couchy, Joel's mother, says to police he really needs to see a doctor, but he does not know he's sick. And that's in stark contrast to the insight that Mr Couchy appeared to show when he was being medicated. Mr Couchy Senior expressed significant concerns to Queensland Police about the need to remove his knives, including his fear. I withdraw that, I'll start again. Mr Couchy Jr., that is Joel, expressed concerns to Queensland Police about his dad removing his knives. He said that the fact that his dad had removed his knives might lead to him becoming broke, living on the street, and potentially put him at risk of being killed, which suggests that Joel Couchy might have had fears for himself at that stage and possibly from the auditory hallucinations. Joel was unable to articulate why the knives were so valuable or why those consequences might result. While the evidence in the brief appears to suggest that the Queensland police officers formed the view that Mr Couchy was unwell as a result of that interaction, they determined that it wasn't necessary for them to take immediate steps to have him assessed or arrested, particularly while he was not presenting as a threat to himself or his parents. Later, on the 8th of January 2023, one of the attending Queensland Police sent an email to Darling Downs District Domestic and Family Violence and Vulnerable Persons Unit requesting that a follow-up occur for Mr Couchy's mental health. That didn't happen. It appears that the email was missed by a relevant officer who was then acting as the mental health intervention coordinator. The inquest will explore whether the attendance by Queensland Police and the subsequent lack of follow-up was a missed opportunity for intervention, which may have resulted in a review by a mental health service and Mr Couchy being reintroduced into the mental health system. The evidence also indicates that information concerning Mr Couchy's interactions with police was not available to the clinicians who saw Mr Couchy from 2020 onwards, or at least not all of it was. And having access to that information may have given the clinicians some visibility. So there's an important issue in terms of the overflow of information between clinicians and between police and clinicians that might have been of assistance. It will be important to hear from those Queensland police officers, I anticipate, about how Mr Couchy was presenting on that day compared to so many other call-outs that they get for mental health. Mr Couchy's experience demonstrates how quickly someone can fall out of the mental health system, and once outside it, the barriers to reintegrating them. The expert psychiatrists retained have identified that in addition to the benefits of early intervention and ensuring people with mental health conditions are encouraged to remain compliant, there must be oversight of their treatment and there must be stable accommodation that facilitates oversight. I expect that Your Honour will hear that they identify that one major gap in our mental health services in New South Wales and other states is the absence of supported accommodation for people with severe forms of mental illness who require basic support and supervision to remain well. I expect the court will hear that from around the mid-1980s in New South Wales, there was a serious shift to move mentally ill people out of institutions and into the community. While that might be an admirable goal given the previous horrors of chronic institutionalisation, it appears that demand for community housing for people who are suffering mental illness, particularly schizophrenia, has vastly outstripped supply. Professor Olive Nielsen will give evidence about an initiative known as Habilis Housing. Habilis is a registered charity recently established to bridge the gap in New South Wales mental health by providing indefinite supported accommodation and care for people with disabling forms of mental illness. It provides oversight for medication as well as accommodation. Professor Anthony Harris will give evidence about the Haven Foundation, which aims to provide that sort of stable and affordable social housing for people with significant mental health challenges and encourages independence for those suffering mental health conditions so that they can manage daily activities and improve their quality of life. I've already mentioned that the court is fortunate to have the expertise of Professor Nordentoft, a leading international expert in relation to schizophrenia based in Denmark. Professor Nordentoft played a key role in developing and implementing early intervention services in Denmark. She'll express her views on the best programs and how mental health conditions, in particular schizophrenia, are managed in Denmark. This includes acute psychiatric outreach, which is available in Denmark, targeting individuals who have severe mental illness or those in crises who can't resolve their problems through a GP on call or by visiting psychiatric emergency room. That service is uniquely staffed by a psychiatrist and an ambulance driver, allowing for emergency visits, even in challenging and potentially dangerous situations. And Your Honour, I expect that you will hear from Dr. Olav Nielsen that sort of emergency outreach work is critical and should be introduced throughout this state. I expect it will come as no surprise that all of the experts are likely to speak of the need for urgent reform to services to alleviate some of the burden on police and to keep the community safe. And I've alluded to the fact that it will be important to hear from Queensland Police about the legislation that they were working under when they went out to assess Joel, how that presentation of Joel compares with other presentations and the limitations on the resources available to them. I expect the evidence to hear in New South Wales and elsewhere that the court should consider a co-responder model so that police can be accompanied in circumstances by trained mental health workers who can take over follow-up, and should also hear about greater community outreach and the accommodation options I've spoken of that link mentally ill persons into treatment. Your Honour, this opening has set out the factual matrix for the inquest and has foreshadowed the evidence to come over the next 5 weeks. So I am nearly finished. And at this point, on behalf of the counsel assisting team and before concluding, can I take this opportunity on behalf, no doubt, of all the lawyers at the bar table, not just my counsel assisting team, to express our deep condolences to the families of those who have lost lives, some who are listening online and some who are in court. We have got to know some family members in the lead up. We feel for you deeply, but we don't pretend to know the extent and depth of your loss. We will really try over the next 5 weeks to conduct this inquest that has you front and centre and at the top of our minds throughout the entirety of the 5 weeks. We remain available throughout this period, so we'll just be in court this whole time and accessible if anybody would like to speak with us or critically to talk to us about things we should be doing differently or better or more sensitively, and we'll stay here for the whole of the 5 weeks to make sure that that happens. Might be time now to take the lunch break, Your Honour.
Just before we do, and just following on from Dr. Dwaran, thank you very much for your opening. I also want to acknowledge that by necessity there's formality because we're in a court. This is an inquest. But I want to acknowledge we're all human and we all have hearts, and our hearts go out to you today. I just wanted to say that because it's formal here, but there is that human aspect of this that we're all feeling for you. So we'll adjourn now and we'll come back at 2:20.